7 weeks.
I bet. You sort of have the mini impact that the YSL people had.
Yes. So everything is on a trial calendar, regardless of the 7 weeks that we were in trial. So I am playing a mean game of catch up. And I spoke to Mr. Brown as well. I conveyed the offer, but I would definitely ask, since I was conveying that this morning, I would definitely ask for his final plea rights to be preserved. I don't know what his next trial calendar date is, but I do want to speak to the state to see if we can negotiate his offer just a little.
Okay. Mr. Harris Brown, you back in here? Hey there. What we're going to do, you had a chance to speak with Ms. Cabrera on the phone? Okay. She has asked that we move your case on to well, let me actually pause for 1 second. There's a PV number on the calendar for Mr. Harris Brown. Okay, not an issue. Okay, great. Mr. Harris Brown, we're back to you. Your case is on the September trial calendar. Thank you. That is. Oh, you checking on that? Okay. You will. Okay. Mr. Harris Brown, your case is on the September trial calendar. So it'll be here at the end of September. That's a month and a half for Ms. Cabrera to work with you and talk with the prosecutor. I think Ms. Cabrera wants to try to see if she can get a slightly better deal for you. And so she's going to keep doing that. And what I'm going to do is keep your final plea rights open. Since Ms. Cabrera was stuck in trial for the last 7 weeks, she wasn't able to spend as much time on your case as she would have liked to. So we're not slowing anything down. We still got the trial date. And if you guys can work something out before then I'll see you before then, okay? I'm gonna ask you to take a seat. We got to check on one more thing. And once I hear about that, then I'll excuse you, okay? All right.
And he's handled his probation violation. Also, just a heads up, that's been handled. First offender revoked, all of that. He's a recent release.
Okay, Ms. Simpson told me that.
Yeah.
Okay. Okay, but not a warrant in connection with the PI case. Just there are new charges floated. Basis for the revocation. And that PI case is not this case. Okay. All right. Good morning. Head on back. All right. Who's checking for you? Your check. Okay. All right. Mr. Stringer. It's area code 229. That's your mom? Your mom? Yeah. Hi, Mom. You always escort your son to court? Well, he's a lucky kid. How old are you, Mr. Stringer? 21. And then the email address, that's you. Okay. And then there's a 470 number. That's your wife. So you have wife and mom here. It's a nice entourage. And then there's a number for a cousin as well. Where is Mr. Stringer's phone number? You don't have a phone? I mean, you got this nice satchel. What's in your satchel? No phone? He doesn't have a phone?
Actually, he's been enjoying a little cool water and.
Oh, got it. No, that's all right. I just want to make sure that Ms. Cabrera can track him. I don't want the story to be, well, she never called me on my number. If she's calling you or Ms. Ashanti or Brittany, one of you will put the phone in Mr. Stringer's hand or say, hey, you got to call your lawyer now. Okay. And Mr. Stringer, if I had to call one of these three numbers as the most reliable to get to you, which one would it be? Mom or wife? Wife. Okay. All right. How long have you been married at age 21? It's a long story. Okay. Are you working these days? What do you do? Okay. So you earn money, you can get yourself a new phone? Your bond says you have to stay away from some guy named Samuel Andrews. Are you doing that? Good. Okay. That's really the main condition of your bond. Keep doing that. And last thing I want to confirm is your address. I got an apartment on Marietta Street. Is that where you stay? Is that where you stay with the person you're calling your wife? Okay. To whom you've been married for an unknown amount of time?
Don't let Mr. Stringer leave.
Okay. Oh, can't leave yet.
No. Yep. I just got a message. Mr. Lumumba says he will be ours.
All right. So even better, that voice you've been hearing, you may have seen the face on the screen. That is Ms. Cabrera. Here, let me do this.
I just need a.
See that face on the screen? That's Ms. Cabrera. That's your lawyer. I'm going to give her all this chicken scratch with all these phone numbers. You're not going to get his number because his phone's at the bottom of a pool. But is there numbers for all sorts of ladies in his life, and an email address? Do you want his case number, or is that in the emails that you had?
I just need, actually, the email I have only has one case number. Does he have multiple cases?
Nope.
Okay.
No, I just got one that ends in 820.
Yes, that's what I have, 820.
Excellent. And we're going to leave this on the September trial calendar. Ms. Davis can get you discovery, or Ms. Wood can. We'll work on that. And then if we need to bump it because that's not enough time, I understand. But we'll keep a little pressure on to see if it is resolvable.
Okay.
Okay. All right. Excellent. Mr. Stringer, any questions about anything? Okay. Good luck with the scaffolding. You guys are good to go.
Because I got an announcement on my camera.
All right. Give me 1 second. I'll write down a bunch of notes here. All right, Mr. Kendall, you represent Mr. Bratton, position 4. What is your announcement?
Yeah, Miss Davis has beat me down and
The usual.
the usual. So, I just got to come on in, but we're gonna resolve it this morning.
Okay.
We're ready to resolve it.
Okay. Well, let's do that. Ms. Rios, are you ready to take Ms. Walker's plea?
Yes.
We
I
could-
was about to send the terms, but it's pretty simple for me to be done.
I think we'll be all right. So why don't we do Ms. Walker, and then we can do Mr. Bratton. Did you have any updates?
I have an update on Mr. Wells, Judge.
Yes.
So, we still on the death certificate, and they give me some more information, so I'm just, now I need my investigator to go look in a different county. for the
Okay.
death certificate. But as soon as I get that, I will get it to Ms. Davis.
Okay. Should we move it to an inquiry calendar
Yes.
rather than a trial calendar? 30 days out? Okay. Mr. Wells, don't hit your hand. You good? All right. We're going to move your case out about 1 month. You got a little more information to Ms. Wood, and they're going to try to track down that death certificate. And I'll see you in about a month. Did you get something in the mail telling you to be here today? Yes? Okay. Well, you get something in the mail telling you to be here in about a month, but Ms. Wood will also let you know that you need to be back here. And we'll see if her team was able to track down this death certificate. So I've got an address of Arno Court. Is that where you live? Good. That's where you get the mail. Any questions? Okay. Can he leave?
Yes.
All right, Mr. Wells, we'll see you around.
And Judge, I have an announcement.
Hold on one second.
It's not that.
He can go? All right. Mr. Harris Brown, you are good to go. Yeah, you'll get something in the mail, but it is September 25th, if you want to write it down. 9 o'clock in here, September 25th. But you'll get notice. And Ms. Cabrera will be talking to you before then. But at the latest, it would be September 25th, right here. All right? You bet. Oh, Mr. Perry, how are you? Ms. Gladden was supposed to tell you you didn't need to come down. She did, and she said he didn't realize he needed to come down. She was here for a while, and we were chatting about your case, and I was wondering where you were, and she said she had been trying to reach you, and then she reached you and relayed to me that you thought you only needed to be here on Thursday. And I said, that's fine. I've heard enough from you, Ms. Gladden. You can tell Mr. Perry he can turn back around. But it's good to see you. I will see you on Thursday when we call the trial calendar, okay? Be on time for that one. All right. All right, Ms. Wood, anything else in terms of announcements? All right, Ms. Rios, you ready with Ms. Walker?
Yeah.
All right.
I had an announcement.
Oh, yes, you did. Yes, ma'am.
That's position 1. I was informed by adult diversion that the defendant never reported and they sent several notices for orientation. So no, he is not in the diversion program.
Got it. And he is not here. So I guess we'll do a bench warrant and see where we go from there for Mr. Hoskins. That one didn't work out. Thank you for that update. Willie Jones. Where's Willie? There he is. How you doing, Mr. Jones? All right, Ms. Rios will chat with you. Sounds like we're working your case out today. Was that your understanding? All right, we'll do that in a little bit. Come on up. Let me know when you're ready.
I am ready, Judge.
All right. Ms. Rivers, you good to go?
Yes, I am. I'm ready.
Great. Okay. Well, let's get on the record in 25 SC 001919, State versus Walker. Ms. Walker is here in court with her lawyer, Ms. Rios. Ms. Davis is here for the state. Ms. Walker, it's my understanding that you're ready to enter a plea in your case. Is that correct?
Yes.
Okay. What's going to happen? Have you had a plea before, or is this your first time?
What's that?
This is my first time.
Okay, so what's going to happen in just a moment, Ms. Davis is going to put you under oath. And she's going to ask you a bunch of questions. They should be things you and Ms. Rios already talked about. You need to answer those questions truthfully and completely. If at any time during the conversation that the four of us are having, you've got questions, you don't understand something, or wait, that's not what I was expecting, I need you to tell me that you've got a question. Will you do that?
Yes.
Okay, great. Then let's get started.
Please raise your right hand. Do you swear or affirm the testimony you will give before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Milwana Walker.
Can you spell your first name slowly and just speak up a little bit for the record?
It's MIAJUANNA.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
24, and I graduated high school.
Which high school did you attend?
Frederick Douglass.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're being charged with a reduced offense? Judge, we are reducing the aggravated assault to an affray, and that is OCGA 16-1132, and that would be a misdemeanor. Do you understand that you're now charged with an affray?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of the indictment and any or all defects therein for the purposes of this plea?
Yes.
Ms. Walker, do you remember having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Attorney Rios, are you aware of any outstanding warrants?
No.
Has your attorney advised you the minimum and maximum sentence for this charge, which would be 12 months to serve, which would be the max?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes.
Do you understand the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has a right to sentence you to the maximum possible sentence on this charge?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? And that's true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Okay. Yes. Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 12 months from today for this misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 25 SC 001919 to the charge of an affray?
I'm guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Can you say that again?
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes that the evidence would show at trial that on September 29, 2022, the alleged victim in this case, Ms. Stephanie Murphy, went to the defendant, Ms. Walker's place of work, USA Deli on Memorial Drive. There was, I guess, some communication on social media, which made her drive to her job. What we were able to see on the video footage, and this occurred at 1156 Memorial Drive in Fulton County, Georgia. But what we were able to see from the surveillance footage, that both parties had friends that arrived, and it was a big fight. I know the warrant does allege that there was a knife involved, but from the video footage, you can clearly see that the defendant has a phone in her hand.
A phone?
A phone. And there are multiple people involved in the altercation, and hence we don't believe that the aggravated assault charge would be sustainable. And that's why we are moving forward with a charge of an affray.
Okay. Did your office have any success almost 3 years later in reaching Ms. Murphy?
We did. So I believe Ms. Murphy and Ms. Walker's children are related. I believe they share the father of their child. And so we did speak with Ms. Walker. I actually spoke with her yesterday, and she is in line with this. She actually wanted it dismissed, but wanted to make sure that Ms. Walker at least got some anger management and was very comfortable with the sentence that we are recommending today.
Okay.
And with that, the state is recommending 12 months probation, anger management, 60 hours community service, and to have nonviolent harassing contact with the victim, because the victim did say they do need to communicate for the sake of their children.
Got it. Okay, thank you. Good morning, Ms. Jackson.
Good morning. How are you?
It's been a minute. Understand you lost a colleague, Ms. Roberts, left the office.
Yes, she did. Friday was her last day.
That's too bad. You guys have a celebration?
Yes, we did.
Good. Well, more work for you. Do you have any criminal history information for Ms. Walker?
Yes, sir. There are no prior arrests on file, Your Honor. Nothing in addition.
Got it. All right. Ms. Rios.
Yes, Your Honor. Ms. Walker is 24 years old. She has here her boyfriend,
There's no kids there.
the father of her children, and her two children, I believe 4 years old and
3 and 10 months.
3 and 10 months. She's currently employed at Stitch Fit. Stitch Fit is a warehouse through a temp agency, and we just ask you accept the plea as negotiated.
Okay. Ms. Walker, what do you do at the Stitch Fit warehouse?
I receive clothes. I mess with clothes, deal with clothes.
But like, do you put them in boxes, put them on hangers,
On
put them on
hangers.
you?
On hangers.
On hangers? Okay. And they go on a truck and go somewhere, or they go into a store?
They go on a truck.
Okay. How long have you been there?
Maybe like a month, 2 months now.
Okay. Good. How many hours a week?
40.
All right. But it's through a temp agency. Could it
Yes.
turn into a permanent thing?
Yes.
Okay, great. You've got 2 kids. They're both here. Is the father of those kids the same gentleman who's got a kid with Ms. Murphy?
Yes.
Okay, that's the guy right there.
Yes.
All right. So you and Ms. Murphy occasionally have contact because what's your kid's father's last name?
Smith.
Smith. Mr. Smith sometimes needs to be around Ms. Murphy because he has a kid with Ms. Murphy.
Yes.
Okay. Are you ever around Ms. Murphy?
No.
Okay. How would you describe your relationship these days with Ms. Murphy?
It's cordial.
It's cordial?
Yes. Like.
Okay.
Yes.
You have pleasant words, no one's throwing punches.
No, because the kids are involved.
How many kids does Ms. Murphy have with Mr. Smith?
1.
One? How old is that kid?
He just turned 3.
Oh, all right. So they could hang out together. They're
They do.
siblings.
Yeah, they be around each other.
Okay, good. All right. So you think having a condition of it's okay for you to be around Ms. Murphy is safe for you?
Yes.
Okay. You get your eyes all big. It sounds like in September of 2022, it wasn't a great situation?
It was a misunderstanding then.
A misunderstanding.
Yes,
Okay.
He was in a relationship with both of us, so
That's complicated.
yeah, it was.
You guys should have been beating him up.
On her end.
Yeah,
So-
okay. Well, Mr. Smith is fortunate that you guys didn't jump him. Do you have any questions about anything we discussed?
No.
Okay. Well, Ms. Walker, I find there's a factual basis for your plea. How many people were you working at USA Deli at the
Yes,
time?
I was actually finna get off work at the time when she
Okay.
came up there.
All right. And the way Ms. Davis described it, it sounds like it wasn't just you and Ms. Murphy, but there were a bunch of folks.
Yes, because she came with someone, so I called someone as well, because I was finna get off work.
Okay. So the posse's got bigger.
Yes.
Hopefully that doesn't happen again. But I do find that there's a factual basis and that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea.
Yes.
And knowing means you've understood all the things we talked about. You
Yes.
agree with that?
Yes.
Okay. Ms. Rios, can someone in my office sign the indictment on your behalf? Ms. Davis?
Yes, Judge.
And Ms. Walker, is it okay if someone signs your name electronically to the indictment?
Yes.
Okay, well, that's what we're gonna do. So I'm gonna follow the recommendation for the most part. You are pleading to a misdemeanor. I'm sentencing you to 12 months of probation, and you've got 3 special conditions, 2 of which you can make go away by completing them. One is complete an anger management course, 1 class, and 2 is complete 60 hours of community service. The third is no violent contact with Ms. Murphy, but that's sort of, if it was violent contact, that'd be a crime anyway. So you can be around Ms. Murphy. It may be that you had a bond that said you can't, but you can be around her now. And I will be happy to end your probation early as soon as you've completed the anger management course. So you document that and you've completed the community service. So there's an incentive to take care of that sooner. If you wait for 9 months to start doing it, that's really on you. But if you complete those 2 conditions, then you can reach out to Ms. Rios, you can reach out to me, and we can close out your probation early. Does that make sense?
Yes.
Any questions about anything we talked about?
No.
Were you supposed to be at work today?
No.
You have Tuesdays off?
Yes.
Well, that was convenient. What days do you work?
Monday, Thursday, Friday, Saturday.
Okay. All right. What are your kids' names?
Carter and Melanie.
And the littlest one is?
Melanie.
Mulaney. All right. Well, if you don't have anything else, you're going to get probation reporting instructions either through Ms. Rios, or she may give misdemeanor probation your contact information. Could be an email, could be a phone call. Don't ignore it, because if you don't show up after they reach out to you, then they send me a warrant and we start this process all over again. Okay?
Okay.
All right. Ms. Rios, anything else?
No, Your Honor, thank you.
That's it. Good luck with everything. Mr. Glenn, good morning. I'm all right. Mr. Lemons is in state custody.
Yes.
So what we need to do is line up a Zoom. Do you need any assistance in connecting with him?
Well, I just have my phone actually on my computer.
Oh, we don't have him. We didn't know that he was in state custody, so he is not with us today. But I only learned today, other people may have known, you may have known, that he wasn't at the county jail. He actually had been sent to GDC custody. And so what we need to do, if you think this is a resolvable situation, which I think it is, but not my call, that's yours and Mr. Lemons's. But if it is, then we'll patch him in virtually from, I think he'll be at Jackson for a little while, and just resolve this so it's not hanging over his head. Do you have a way of contacting him, or do you need a connection with GDC to do that?
Probably need a connection with GDC and also too, if I could have a moment to conference with the state just to make sure we're on the same page and everything.
Okay.
So that'd be good.
Well, what I'm going to do is send an email to you. I'll copy Ms. Davis. That email to you is going to have the contact information for GDC, how you could line up a teleconference with Mr. Lemons that is privileged, so you guys would speak privately. And we will work, to set this down for a plea date in a few weeks. And it'll just need to be, you're welcome to be here in person, but your client's going to be virtual. So if it's easier for you to Zoom in from your office or wherever, that's fine with me. All right? All right.
Thanks. I'll go ahead. So I should just, since we don't come to resolve it, they have to just go ahead and get the comments from Mr. Nolan.
Yep.
And I'll have those for you.
Exactly. So you are free to go now. You'll have Ms. Davis's contact info through the email that I send out that gives you the GDC teleconferencing info. All right?
Thank you.
Sure. Same. All right, Mr. Kendall?
Yes, sir.
Want to bring your client on up? Ms. Davis, are you ready?
Yes, Judge, I'm ready.
All right. Well, let's get on the record in position 4, State versus Antoine Bratton. Am I pronouncing your name correctly?
Bratton.
Say it again.
Bratton.
Broughton.
Is that not what I said?
It's how you said Bratton.
Okay. I'm trying to say it that way. Anyway, we've got you here along with your lawyer, Mr. Kendall. Ms. Davis for the state. It's 24 SC 005 020. And Mr. Bratton, you are prepared to enter a plea?
Yes, sir.
Okay. Ms. Davis is going to put you under oath, ask you very similar questions to what you just heard her asking Ms. Walker. And I will hear from her. I'll hear from Mr. Kendall and you if there's anything you want to add, and we'll see where we go. All right. Let's get started.
Please raise your right hand. Do you swear or affirm that the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name for the record.
Antoine Bratton.
Can you spell your first name and pause and then spell your last name?
ANTOINE BROUGHTON.
Are you at this time under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
44, 10th grade,
What high school did you attend?
South Atlanta.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with 1 count of burglary?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Mr. Kendall, about all the facts and circumstances known to you regarding the charges in this indictment and any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes.
Mr. Kendall, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
Yes, we do.
Mr. Bratton, do you remember having been arrested on these charges?
Yes, ma'am.
The state is unaware, Your Honor, of any outstanding warrants related to this matter. Attorney Kendall, are you aware of any outstanding warrants?
No outstanding warrants.
Mr. Bratton, has your attorney advised you the minimum and maximum sentence for the charge to which you're pleading to today?
Yes, ma'am.
Okay, the maximum sentence would be 5 years.
Hmm.
Okay. Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has a right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
Mr. Bratton, today, if I sentence you to more than what Mr. Kendall asks for, you're able to withdraw your plea. That's what's significant about the final plea date. So I'm making numbers up, but if Mr. Kendall says, Judge, it should be 2 years probation, and I say, I think 4 years probation, you and Mr. Kendall will have a chance to talk. And if you are dissatisfied with that sentence and would rather go to trial, no questions asked, you just say, that's really not what I'm interested in doing. And then we just keep your case on the trial calendar. I'm not saying that because I think I'm going to disagree. I haven't heard anything about you or the recommendation, but I want you to know that you'll have that opportunity to ponder if my sentence is different from what Mr. Kendall asks for. Okay?
Yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts.
Yes.
You understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would. That's true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which can carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
You understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a trial.
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney to trial your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand you have only 4 years from today for this felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 24 SC 005020 to the count of burglary in the second degree?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Judge, we believe that at trial, the evidence would show on January 17, 2023, officers with the Atlanta Police Department were dispatched to 786 Cleveland Avenue in Atlanta, Georgia, in Fulton County, to an extra space storage facility in regards to a burglary that occurred on site. They were actually called out there by a manager after noticing a unit had been broken into. Upon arrival, officers met with the owner of that unit, Mr. Mikan Diallo, and he indicated that someone broke into a storage unit and stole about 60 pair of Nike shoes. The surveillance footage revealed there were 2 males who entered the facility, one of those males being the defendant. That the defendant did use his pen to enter the extra space storage facility because he also had a unit there, and then was captured on the surveillance footage removing boxes, Nike boxes of shoes, and exiting the building. The manager of the facility also recognized the defendant, and that's how they were able to identify the defendant as a person being involved in that burglary. We are recommending to the court that the defendant do 5 years of probation, that we're reserving restitution. We did try to attempt to reach out to the victim, but we're not able to. And so at this time, we don't have an amount of the value for the sneakers. So we're asking to reserve restitution, that Mr. Bratton complete an anti-theft course, that he obtain his GED if he does not already have it, complete 60 hours community service, stay away from the incident location, meaning for him to, I guess, complete the term of his, if he's still renting at the extra space facility, but to stay away from that facility, and then of course the victim. And that is it.
That's it? Okay, thank you. Ms. Jackson, do you have any criminal history information on Mr. Bratton?
Yes, sir. There are 12 cycles. The last arrest was May the 13th, 2014 out of Gwinnett County for a probation violation. There are prior felony convictions, one in 2015 for possession of a firearm by a convicted felon, one in 2002 for criminal use of an article with an altered ID or mark, one in 1999 for the theft by receiving stolen property. Nothing in addition, Your Honor.
All right, thank you so much. Mr. Kendall, what do you want to tell me about your client and this case?
Yes, Your Honor. My client and his wife, who's in court here, he's employed, gainfully employed with A National Limousine Service. A National basically runs the MARTA I guess you call it paratransit and the airport shuttle service.
That shuttle. We've talked about this before. That's when I met you. That awful shuttle service.
It's
not your fault, but boy.
That's the city's fault, you know.
Someone leaves poor passengers standing there forever trying to get from international to domestic. Ooh.
We've improved that.
Okay, I'm sure.
That's another one of my clients.
I'm confident your tentacles are into that, no doubt.
So I had to take up for my client.
Okay.
But they've improved that, John. But he's gainfully employed, Your Honor. I think the facts that the state have stated are true. He had a storage unit there. I mean, that door was a little enticing. It was kind of.
Some nice shoes on the inside.
It was a little loose that day, Judge.
Yeah.
And, you know, temptation got the best of him. But he has owned up to what he did, Your Honor, and we would ask you, we like the numbers that you gave in your example better than what Ms. Davis did.
But you've negotiated in good faith with Ms. Davis.
Yeah, but I saw you looking at the computer, so I know you were looking at what you thought it should be, so.
I was looking at how much time Mr. Bratton already served in this case.
Exactly.
16 days.
And I think you probably think it should be a little less. And so if you want to go with the number that you gave in your example, Your Honor, we're not going to object to it.
Got it.
Ms. Davis probably won't object to it either. But if not, we will accept the recommendation of Ms. Davis.
Okay, I appreciate that. Mr. Bratton, you now, I think Mr. Kendall said 2 jobs. You drive the super slow limos at the airport. What was the other thing you do?
No, he works for the company that does.
Oh, you don't actually drive them?
Yeah, I drive. I do a lot of that. I mean, I'm a mechanic. I wash.
Okay, you help keep it running slowly. But you had I thought you had a second gig too, or maybe I missed. Everything you do is with A National.
Yes, sir.
Maybe A National does something away from the airport as well.
Right, they do the.
Oh, the paratransit for.
Paratransit
Okay.
and the airport.
That's important stuff.
Right.
Okay, how long have you been with A National?
Well, I've been with the company since 2013, but I've been back since 2 years. For 2 years.
Why did you stop working there?
Well, I had got another job and ended up going back.
Okay. All right, well, welcome back, I guess. This case, a while ago, 2.5 years almost, did you know what was in Mr. Diallo's unit, or you were just sort of trying a door and maybe they're gold bars, maybe they're Nike shoes, maybe there's a dead rat?
Nah, I knew what was in there.
How did you know Mr. Diallo, or just in being at the unit you'd seen before, like that guy always has a bunch of sneakers in there?
No, I actually just seen him that one time.
Okay. All right. Anything you want to add?
No, sir.
Do you have any kids?
Yes, sir. 3.
3, how old are they?
16, 6, and 12.
16, 6, and 12. So a high schooler, middle schooler, and a little one.
Yeah.
Any of them live with you?
All of them.
All of them. Okay. Are they back in school now?
Yes, sir.
Where does the 16-year-old go?
Riverdale High.
Okay. Any questions about anything we discussed?
No, sir.
Do your kids know you're here today?
Well, I told the oldest one. I ain't tell my youngest.
Okay. And what do you tell the 16-year-old about what you're doing in court today?
Well, I just told him I had court. I didn't tell him the situation. But I talked to him when I was incarcerated before you let me out.
When you had your bench warrant, what'd you tell him as to why you were in jail?
Yeah, I told him this ain't what he want to do. That it's not the place.
Okay. Well, I hope he learns from you. Is he seem pretty squared away? What does he do in school?
He's doing baseball and he just got accepted. What's the college? He just got accepted in Georgia Military College.
He's only 16 and he already got in there?
Yes, sir.
we've been doing them all, like, the straight A student.
Wow, fantastic. Good job, parents. Is he going to play baseball at Georgia Military?
I'm not sure. She know he talked to her more than he talked to me, so she.
Go to school. I mean, baseball is okay, but I want to focus on this.
Focus on the academics. Well, he seems to have figured those out. Good for you guys. All right. Mr. Bratton, I find there's a factual basis for your plea. This seems like it was more a hustle, greed thing and not you're an evil, dangerous person. But you did what you did. I also find that your plea is knowing and voluntary. No one's forcing you into this plea, and you understand everything we've been talking about. You agree with that? I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a little problem, and I hope you have no problems, but if you have a little one, you miss a meeting with an officer or something like that, you don't have to come see me. They'll work through the consequences with you. But if you get arrested for something again, it's more serious, that comes back to me and we'll work through what revocation might look like. Mr. Kendall, do you authorize someone in my office to electronically sign your name to the indictment?
Yes, I do, Your Honor. We asked one other thing, Judge. Will you be amenable to terminating this after 3 years?
So what I'll do, I'll get to that, but I am going to set a behavioral incentive date. So if Mr. Bratton is doing fine, which I suspect he will be, then that'll happen naturally. But it's okay if we sign your name.
Yes.
All right. And Ms. Davis, can we sign your name?
Yes, Your Honor.
Mr. Bratton, is it all right if someone electronically signs your name to the indictment indicating your guilty plea?
Yes, sir.
That's what we'll do. So, Mr. Bratton, I am, given the fact that this happened 2.5 years ago, and you seem to have stayed out of harm's way since then, going to sentence you to 4 years probation. Special condition of probation number 1 is get your GED. And you need to have enrolled in that GED program within the first 2 months of your probation. So I want that clock to start running. You'll need to complete 60 hours of community service. You'll need to, do you still have a storage facility at that place? So stay away from that storage facility on Cleveland. If it's still there, sometimes these things come and go, but
Still there.
assuming it's still there, no storage facility for you there. And stay away from there and leave Mr. Diallo alone. Did you know him outside of the fact that he had a unit full of sneakers near you?
No, sir.
If he broke into your unit, what would he have found?
We actually was just moving all our house stuff.
Well, it's good that didn't happen to you. You'd probably be pretty upset. I will set a behavioral incentive date of August 6th, 2028. So if you've done all the things you need to do, oh, and one more condition, take an anti-theft course. Unlike GED, which is learning a whole bunch of things, the anti-theft course is a one-off. You'll just take that. If you've completed all those conditions and otherwise been a model probationer, then on that behavioral incentive date, probation can close stuff out. They'll send me a letter saying, Bratton's been nothing but good. And I'll say, then let's be done. Let's let him move on with, by then you'll be senior executive at A National. Maybe the buses can run more regularly by then. So that's your probation. Any questions about any of that?
No, sir.
Mr. Kendall, anything else on behalf of your client?
No, Your Honor, but we're gonna take you on a tour of the airport though, because you gotta get better PR out of the.
So I've been to the airport. I know how it works, and I have waited many moons for the A National shuttle. I've been following the whole contract negotiation stuff. I figured you were involved because that contract didn't get canceled. Ms. Davis, anything else from the state?
No, Your Honor.
Mr. Bratton, last thing is reporting to probation. What county do you live in?
Clayton.
Clayton County. All right. Ms. Simpson, who's seated right over there, is with probation. She's going to give you reporting instructions. I don't remember where in Clayton it is, but she's about to tell you. And you don't want to miss your date there because that's when stuff, they're going to send me a warrant if you're not there for that first session. Okay. You can drive an A National bus all the way down there, but leave a couple hours early if you're in one of those buses.
So, Mr. Ross, your reporting date will be August 15th
Okay.
at 8 a.m. I will give you the contact information for the Clayton office. It's in that South Lake area complex. So
Okay.
it's shouldn't be too far from you.
Okay,
But I will give you enough information.
okay, thank you.
All right, that's it. Good luck with everything. Mr. Kendall, always a pleasure. Thank you for your time.
Appreciate it. Thank you.
Mr. Kendall.
We still have Ms. Kim on the call. Did you have a chance to speak with Ms. Kim?
Our emails were communicated via chat.
Okay. Hey, Mr. Matthews, how are you?
Good morning, Rod. I'm doing well. How are you today?
I'm well. Mr. Roberts was here and told us you were on your way, so all is good. This is on for final plea.
Your Honor.
And I don't know, I think you and Ms. Davis, I think she told me you two hadn't had a chance to confer much.
We have not had a chance to confer much. I did receive an offer this morning, I believe. So I have not had an opportunity to go into grave detail with Mr. Roberts concerning that. There was also a desire on my part to explore the search warrant. As the court may be aware, I've been kind of tied up for about a couple months in a trial next door.
You were next door. Yes, Ms. Cabrera had the same, hey, could I have a little more time on some of these cases?
Yeah. So we started that trial on June 2nd and we wrapped it up on July 21st. So I would like an opportunity to explore the search warrant to determine if there are any issues with the warrant. I'd like to also take a look at the body camera. I believe there were some alleged statements that may have been made concerning Mr. Roberts in that statement, and also an opportunity to talk with the prosecutor regarding the recommendations. I would respectfully ask the court for some consideration to push this final plea. If we can just kick the can down the road just one more time here, give me an opportunity to do those things. And if I need to particularize any motion, I can do that as well.
Do you have the search warrant?
I looked through the case and I did not see the search warrant. Perhaps it may have been sent some time ago, but I was going to get with the prosecutor to get that sent to me expeditiously if it has not already, and then proceed accordingly.
So you filed, I guess it was a placeholder. Wonder why this case, oh, it was in non-complex.
Non-complex.
I was going to say all these entries, it should have resolved. Yeah. And did you have the case when it was in non-complex?
I did, Your Honor.
Okay.
Yeah, and then it got transferred.
It did, as non-complex likes to do.
Yeah.
So you filed a motion to suppress, a Jackson-Deno motion, but those look like they were right when you entered, so they were placeholders.
Correct.
Looks like they sent some discovery in October of 24. That is warrant 33 video. So you should have received a bunch of discovery, but that evidence.com link was in October of 24.
Okay.
So
Another thing then, I was in that other case.
You've managed to. How about you stay out of cases like that just for a little bit?
And that would be my desire.
Let your son handle those.
There you go. There you go.
You did get a new link on May 14th. Ms. Dilligard, who was Ms. Davis's predecessor, I think renewed that link because it's the same 33 videos, 10 documents, 1 audio. So you should check.
Yeah.
May 14th, May 15th, there'll be an email that went to your work email address. I can see that. So look for that. But what I'm going to do is this. I'm going to keep the case for now on the September trial calendar. It's not till the end of September. I'll preserve Mr. Roberts' final plea rights.
Okay.
And I'm going to give you a couple weeks to review the discovery, to obtain, if you don't have it yet, even though it's been sent to you twice now, to obtain and review the discovery and then let me know. In fact, I do have some particularized motions. I read the search warrant and I want to litigate it. Or, yeah, my client was asked, what'd you do? And where are these drugs from? And he wasn't Mirandized. Whatever it is that you observe, if you think they are non-frivolous motions to be heard, we should hear them.
Okay.
If we can fit that in before the trial, great. If we can't, then we need to move the trial date. But I just like to keep that as a focusing device. The case is old, not your fault. It was bounced out of non-complex. but it's still hanging over Mr. Roberts' head. He's on bond, so he has to navigate life differently than if this case were resolved.
Right.
I think what I'm going to do is send an email to you and Ms. Davis saying, here's some deadlines. I need an update by date X, which would be a few weeks out.
Okay.
That gives you some time or your team's time to go through the discovery to say, it doesn't look like we've got a good faith basis to challenge the warrant, or we do, we need a suppression hearing. And then we'll figure out when to do that. My guess is if we need a suppression hearing, we'll probably have to move the trial date, which I'll do. But you may look at it and say, they actually did a good job with the search warrant, or at least good enough,
Right.
that it doesn't make sense to fight it. And then you and Ms. Davis can be talking about things, and I would see you and Mr. Roberts on that September 25th date, but he'd still have his final plea rights.
Okay, thank
Does
you.
that work?
Yes, absolutely. Thank you.
Mr. Roberts, remind me which one is Mr. Roberts. Have you been following what we've been talking about?
Yes, sir.
Any questions about anything I said?
No, sir.
Okay. You've got a great lawyer. He's just been a little tied up in these other cases. Fortunately, your case is not a 7-week trial. If we have to try your case, my guess is it's a 2-day trial, and that's a much more bite size for everyone.
Thank you, Your Honor.
You're still on bond, Mr. Roberts, so whatever those conditions are, make sure you comply with those. Mr. Matthews will be in touch with you after he's had a chance to look at the discovery to give you his impression of, I don't think there's anything to fight here, or actually we need to have a hearing, and then you'd need to be here for that hearing, okay? All right, Ms. Davis, anything from the state?
No, Your Honor.
All right,
Thank you so much, Your Honor. Pleasure to see the court.
same, you guys are good to go.
Yeah.
Judge, is Mr. Brown still in the courtroom?
No, I let him go. There was a concern about a warrant, but that concern dissipated.
Okay, perfect. I wasn't sure, and you were doing some pleas, so I didn't want to interrupt. All right, I
Nope.
just needed to know that. Other than that, I think that concludes whatever it is that I have today. Might be excused.
Yes, we will email you Mr. Stringer's mom's, wife's, and cousin's phone numbers. He's got quite the harem, and his email address. And you can take it from there.
Okay, perfect. Thank you, Judge.
All right, bye-bye.
Bye.
Did Mr. Murf ever make it here? He's here. All right, so Ms. Kim, your client's here. We'll make sure Ms. Davis can, have you guys been communicating electronically somehow?
Yes, Judge, we have a negotiated resolution for your consideration.
Do you need to talk with Mr. Murf, or have you been communicating with him as well?
I spoke to him as well, Judge.
Okay. Well, we can do that when Ms. Davis stepped outside for a quick second. When she comes back in, why don't we handle that?
Great.
And Mr. Murf, am I saying your name correct? There's not a Y at the end? Just plain old Murf. Works for me.
Your Honor, can we handle Mr. Narsworth Davis? We are not doing the final plea hearing, so we're going to have a discussion.
Mr. Davis, yes, we are doing what?
So he had a request about his ankle monitor, and then we would also, this would be asking for this to go to a trial calendar. We would need more time to, and keep his final plea rights intact. We both need to do more investigation on our parts and.
Meaning state and defense?
Yes.
Okay.
So we do have to get an offer this morning today, but it hasn't been that much time to look up it. We just got it today. And I think that offer might change depending on what we find out. The type of cases, from what my understanding is, there will be one person saying so, no other. We're trying to figure out if there's any other corroborating what the discovery I've gotten so far. I don't see any. It's not a lot. Sorry, I'm trying to figure out what's missing.
Okay. So Mr. Davis has been paying for his own ankle monitor for
I think.
20 months. We changed it to county paying for it.
County paying, once the request for it to be removed completely.
Okay, it looks like in May, you're right, it became, well, he had his curfew was lifted and then he had the option of showing up to Second Chance to get a county funded one installed. Did you do that?
Yes, sir.
Okay, all right. So Ms. Davis, in a moment, we're gonna take the plea in Mr. Murf's case. He's here, his lawyer's online, but we're talking about Ms. Clark and Ms. Rios's case
Oh, understood.
first, just to give you a breather. So Ms. Rios, your request is, keep it on the trial calendar, preserve final plea rights, and remove the ankle monitor.
Yes, sir.
All right. Ms. Clark, what are your thoughts first about, yeah, we need more time, there may be some more work that both sides need to do, preserve final plea rights?
Your Honor, the state has no problem with that, and I agree. Ms. Rios provided some information from her client's perspective. I want to look into it.
Okay. If I go back to the bond. So Mr. Davis was supposed to have no contact with a particular individual and stay away from Union City, so a geographical area, and then school. His curfew is gone, but he still needs to stay away from Union City and the KIPP Atlanta Collegiate. Do you have a perspective on the ankle monitor piece?
No, Your Honor. I will defer to the court.
Okay. Ms. Rios, this case will be, it sounds like, resolved on the September trial calendar, if not before. What is your client telling you about the issue with the free ankle monitor for basically another month-ish?
It's just interfering with his day-to-day life and just would prefer it. He hasn't had any issues since he's been on, I believe, had an ankle monitor. So he's just requesting.
Okay. And his alleged connection to the person he's supposed to stay away from, did he work at this school or?
He's working at the school.
Okay. Mr. Davis, where do you work now?
Particular time, I'm refereeing football and basketball. Due to the fact of the circumstances of what's going on, we do the background check.
You can't get a job. Got it.
I've lost jobs, $100,000.
The school you're supposed to stay away from, you don't do any refereeing there? Okay. And any reason you need to referee in Union City? Okay. All right. Then I can modify the bond again to get the ankle monitor off. You'll let the victim's family know that?
Yes,
Okay,
sir.
Ms. Clark. Then what we'll do is move Mr. Davis's case to the trial calendar, the September trial calendar, preserve his final plea rights. Ms. Rios, if before then you and Ms. Clark reach some understanding, let's get everyone in here. Otherwise, Mr. Davis, I'll see you on September 25th. You'll get notice in the mail. Ms. Rios will be reaching out to you. I will do an order that modifies your bond one last time. Anything else, Ms. Rios?
No, Your Honor, thank you.
Ms. Clark?
No, Your Honor.
Okay, all right. Do you need Mr. Davis to stick around?
No, Your Honor.
All right, Mr. Davis, you are free to go.
This is the one.
Oh, for this morning's calendar? Yeah. Oh, because he's stuck here. Okay. Who's providing security down in? All right.
the other one.
Ms. Kim, I have been asked by the deputies to we got a couple folks in custody and we need to deal with them first. Then we'll handle Mr. Murph's case. I appreciate your patience.
Thank you.
So one of them is a plea? Didn't mean to get you mid-candy.
We can handle
Well, who's the other person in custody?
Yes.
Davis. Is it for this afternoon? The only Davis I have was the guy who was sitting right there, who just walked out. That's just to arraign him. So that's fine. So why don't, since she's not in here, that'll be quick. But why don't we start the plea with whatever name she gave, and then we can knock out Mr. Davis. Ms. Nelson got him here quickly. Great job. Is this Mr. Pullins who's coming out?
Yes.
He's the guy with 1 million years of probation. Okay. Hey, Mr. Pullins. All right, come on up to the podium, please. Hi there. All right, how are you?
Who's the gentleman that we're taking that monitor?
Position 15.
Thank you.
Ms. Davis, are you ready on position 7?
I am ready.
Doing a great job pivoting with these. Then let's get on the record. This is 25 SC 001 498, State versus Dontrellis Pullins. Mr. Pullins is here with Ms. Rios and Ms. Davis is here for the state. Mr. Pullins, my understanding is that you are ready to enter a plea in this case and will also handle a revocation in another case you have. Is that correct?
Yes, sir.
Okay. Ms. Davis will put you under oath and ask you a bunch of questions about your rights as a criminal defendant. You need to answer those as best you can and let me know if at any point you've got questions of your own. Will you do that?
Yes, sir.
Thank you. Ms. Davis?
Please raise your right hand. Do you swear or affirm the testimony you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name for the record.
Dontrellis Deshaun Pullin.
Can you spell your first name?
Dantrellis.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
Are you able to read, write, and understand the English language?
Yes, ma'am.
How old are you and how far have you gone in school?
I'm 48 and I had got a GED.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses? Possession of a Schedule II drug, willful obstruction by violence, a drug object, and another obstruction charge.
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Rios, about all the facts and circumstances known to you about this case, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Do you remember, Ms. Rios, do you waive formal reading of the indictment and any defects therein? Thank you. Mr. Pullins, do you remember having been arrested on these charges?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to this matter. Attorney Rios, are you aware of any outstanding warrants?
No.
Mr. Pullins, has your attorney advised you the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
For the possession of a Schedule II substance, which is methamphetamine, the minimum is 1 year, the max is 15 years. For willful obstruction, the minimum is 1 year, the max is 5 years. For a drug object, it is 12 months. And for willful obstruction, it is 12 months.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes, ma'am.
Do Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from our negotiated plea today, that you have the right to withdraw that plea?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by you, by your attorney, or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand that?
Yes, ma'am.
You understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to indictment 25 SC 001498 to possession of a Schedule II substance, willful obstruction by violence, drug object, and another count of willful obstruction?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes at trial, we would prove that on November 9th, 2024, at 232 Forsyth Street in Atlanta, Georgia, in Fulton County, this is, I believe, the Greyhound bus station, that an officer was on patrol at the bus station. He noticed the defendant, Mr. Pullen, standing outside the front entrance, what he perceived to be weighing drugs. He observed a scale, and then the officer made contact with the defendant. There was a scuffle for the arrest. Mr. Pullen did not listen to the lawful commands of the officer. A taser was drawn, but eventually they were able to secure Mr. Pullen's. They did locate a crystal-like substance that was confirmed by the GBI to be meth. And so with that, it's my understanding that the defendant has been in custody, I want to say over 200 days.
209.
And so we are asking for the sentence to reflect 5 years of 200 days, the balance on probation. One of those conditions of probation being his participation in and completion of the Hope House program. Because the Hope House program incorporates a drug and alcohol component, which we believe that is an issue here, we are not going to add that to the sentence because that is a part of the program. We are also asking that the court order that he stay away from the Greyhound location without a lawful purpose, AKA a ticket. And that is it for the state.
Can you give me, I was doing the math on how much time he's been in. It's Hope House, stay away from Greyhound, absent a ticket. But what was the amount of time, probation or time to serve?
5 years, with 200 of those days being in custody.
Okay.
And we are doing a downward departure from the minimum required time by consent. Because I think that the minimum is like a year.
For which?
For the methamphetamine and for the willful violence towards the officer. There was a scuffle.
Oh, okay. But I think those are probatable anyway, so I think we're good.
Yeah.
All right, thank you. Ms. Jackson, if you have any criminal history information on Mr. Pullins, I would appreciate it.
Yes, sir. There are 35 cycles. The last arrest was August the 10th, 2022, with the City of Atlanta Police Department for possession of marijuana less than an ounce and possession of Schedule 1 or 2 controlled substance and possession of Schedule 1 or 2 controlled substance with the intent to distribute. Those charges were dismissed on October the 27th, 2022. He does appear to have prior felony convictions, one in 2010 for obstruction of an officer and entering an automobile, one in 2012 for theft by shoplifting, one in 2008 for possession of cocaine with the intent to distribute, one in 2005 for possession of cocaine with the intent to distribute. There's an additional one in 2005 for possession of controlled substance. It's one in 2002 for theft by receiving stolen property, one in 2001 for entering an automobile and theft by receiving stolen property, and one in 1999 for theft by receiving stolen property. There are misdemeanor convictions and a sentence. It's one in 2018 for giving false information to an officer and obstruction of an officer. He received a nolo contendere sentence in 2013 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Well, that was plenty. Thank you. Ms. Rios.
Yes, Your Honor. Mr. Pullins is 48 years old. He's from Atlanta. He has a fiance and stepchildren, ages 14 and 15. He is fully blind in one eye and partially blind in another eye. He was trying to break up an altercation and he was wounded during the process. He's trying to get disability for his eyes. He has a strong addiction to meth that he's been dealing with for years. I have gotten him we've gotten him accepted to the Hope House program. He's been very adamant since the start that he wanted some type of program. And I do believe since he hasn't had anything like that before, that with the help of this program, this could kick his drug addiction. And he just wants to get on disability and be able to be a father. I believe he has a child on the way. And so he wants to turn his life around to be there for, I think this will be his first biological child. So he can support her. His fiance has been very involved. She calls me all the time, calls Ms. Ross all the time. And so she wants him to be out to be there for the birth of his child.
When is the child due, Mr. Pullins?
Sometime in September.
Okay. I heard you. Okay, well, I'm excited for you and your fiance. Do you know if it's a boy or a girl?
Well, it's a boy.
And your fiance already has a few other kids?
Yes, she got older kids, but the step kids that she's talking about, that's with one of my exes that I be taking care of.
Okay, got it. How long have you struggled with meth?
Well, when I had got assaulted with my eyes, it was kind of hard for me to sleep. So I started using meth so I wouldn't fall asleep, because when I used to fall asleep, I used to catch nightmares.
What happened? You were trying to break up a fight and that's when you got hurt?
Yes, sir.
Okay. How long ago was that?
February the 3rd, 2023.
Just a couple years ago.
Yeah.
You had a bunch of issues before then. I heard about your criminal history and they seem consistent with having an addiction back then as well. Were you using something other than meth back in the 2010, 2012, 2000?
It was cocaine.
Okay.
But during the time when I had got assaulted, I stopped using cocaine because that was the primary reason why I got assaulted. And then I had went legally blind in both of my eyes for like 4 months. And it was I was at my mom's house, and it was kind of hard for me to sleep, but they was able to recover this eye. And when they recovered the eye, I was able to move around, and I was able to go and get the drugs that I need to keep me up.
Okay. Ms. Rios, Hope House is a great program. It's residential. You'll be there for a while, but it's not drug court. I'm curious if you explored drug court.
They said he cannot go to drug court.
Did they say why? Or it was just no?
I have to look, I believe based on just the charges. I believe the email said it was just based on which is surprising because I feel like I've sent people with these charges.
Right, these are pretty standard charges. Okay, you explored it, it didn't work out, is the answer. All right. Mr. Pullins, I'm gonna ask you some other questions in a minute, but is there anything you want to add?
No, sir.
I know you're anxious to be out and be there for your child, but the first few months at Hope House are fairly restrictive. I think you're able to communicate with people, like phone them, and there may be a computer where you could email someone, but you don't necessarily get to go out and about. Do you understand that?
Yeah, when he came to interview me, he told me, he said I'll be on house arrest for the first 30 days, and he gave me the whole rundown.
Okay. I just didn't want you to be surprised, and we don't call it house arrest there. It's just that you'll be staying there. You won't have a pass to go down to the grocery store. Or
I'll be on the monitor, on the leg monitor.
Okay, that may be true too.
Yeah.
But I just wanted you to know that it could be that your son is born, but you're still at Hope House, not able. And maybe the gentleman you talked to said, "Oh, we'd give you a pass so you could be at the hospital."
That's what he said.
Did you talk to him about that?
Yes,
okay. All right. Good. Do you have questions about anything we discussed?
No, sir.
All right. Well, Mr. Pullins, when you had this encounter at the Greyhound bus station, Ms. Davis mentioned there was a taser. Did you get tased, or they took it out and that's when you said, all right,
No, see what the situation was, I was on drugs, and when he approached me, I got paranoid and I freaked out. And when I tried to get away, and he hit me 2 times, hit me on both sides, and he slammed me on my elbow and broke my elbow. And I'm trying to let him know that you done broke my arm. But he wasn't trying to, he was still trying to, and I'm trying to tell him to get out my arm.
Okay.
And he shot at my elbow.
Okay.
Now I got a plate and 4 screws in my elbow.
Sorry to hear that. I do find there's a factual basis for your plea, and that your plea is knowing and voluntary. I'm going to sentence you pursuant to the Probation Options Management Act, which simply means that while you're on probation, if you have a minor violation, a technical violation, you and probation will resolve that. But if it's more substantive, then you come back in front of me and we'll figure out what to do with that. Okay. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Davis?
Yes, Your Honor.
And Mr. Pullins, can we sign the indictment for you?
Yes, sir.
We'll do that. So I'm going to vary from the recommendation only a little bit. I want to build in a little bit more probation, not nearly as much as you have on your other case, but I want to make sure that if for some reason Hope House doesn't work out, that we have the opportunity to get you treatment that you can't walk away from. And that means I just need a little more time on probation for you. So on count 1, I'm going to sentence you to 7 years to serve 7 months with the balance on probation, and you'll get credit for the time you've been in. Count 2 will be 5 years to serve 7 months. That'll run concurrently with count 1. And then counts 3 and 4 are both going to be 7 months to serve. They're all running concurrently with each other. So it's a total of 7 years to serve 7 months. So that gives us 6 years and some change on probation. Special condition of probation number 1 is to enter into and complete the Hope House program. They do not lock the doors. You can walk away. If you walk away and they have to kick you out of the program because you absconded or for whatever reason, they have to expel you from the program, that's a special condition of your probation. You're going to come back to me and we're going to look for a different approach to getting you drug treatment because you need to get your arms around that addiction. Important for your health, important for your newborn and your fiance. Did you look like you had a question?
Yes, sir. What if I complete the Hope House?
That's great. You should complete the Hope House. You also need to stay away from the Greyhound bus station unless you have a ticket in your name for a bus that has not left yet. Don't work to get a ticket for a bus that left 6 months ago and use that ticket as a way to loiter around there and sell or use or whatever's going on. But my hope is Hope House gets you out of that rut. Have you had a job before that wasn't a hustle?
Well, I used to be a barber before I got assaulted.
Okay. Probably be hard to do. I don't know that people will want you holding scissors around with one good eye. But Hope House can help you plug in with other kinds of work. You may want to transition from Hope House if they help you with your sobriety. Georgia Works is a great place that's just a few blocks away, and they can provide some housing for a while and get you some construction training. So there are options, but the only condition of your probation in terms of programs is the Hope House program, and that you stay away from the Greyhound bus station unless you've got a valid ticket for future travel. And I will set a behavioral incentive date of August 6th, 2028. What that means is if between now and then, that's 3 years from today, you've graduated from Hope House with flying colors, haven't been arrested, everything's been good, we can end your probation early.
Okay.
I'm just building in that extra time, not because I want you to be supervised, but again, if Hope House doesn't work, if you don't open yourself up to it and embrace the program, then we'll have a plan B to get you the drug treatment.
Thank you, sir.
You're welcome. Thank me by doing Hope House and not walking away from it. Ms. Davis, anything else on this case?
No, Your Honor.
Ms. Rios?
No, Your Honor.
Mr. Pullins, you have another case for which you have decades and decades of probation. That case is 19 SC 166371, and I'm prepared to handle the revocation in that case as well if Ms. Rios, you're comfortable with that and are waiving any due process notice rights?
Yes, sir.
Okay. Mr. Pullins, in that case, I'm going to revoke 5 months and give you credit for the time you served. I can't revoke more than that and give you credit. It will start, if it's more than 6 months, it starts to get complicated. So I'll give you credit for the time served. I'm going to reinstate the balance, but I'm going to create a behavioral incentive date in that case as well. Because you have over 30 years of probation remaining on it. And I hope you're alive 30 years from now, but I hope you're not on probation 30 years from now. So I'm going to add that same behavioral incentive date of April 6th, 2028. If you get squared away, you're going to be 50 by then, and have turned a corner, then we can close out that probation as well. Okay? But I'm also going to add as a special condition of probation in the 19 SC case that you successfully complete the Hope House program.
Yes, sir.
Because if you don't, forget about the behavioral incentive date. That didn't work out. And that's just all the more time to work with to get you into what will be a custodial drug treatment program.
All right, thank you.
Okay. Ms. Simpson, do you need anything else in connection with the revocation?
It's the last one, which I was complaining.
So he's going to be at Hope House, and I can give you that address.
Oh, then I have.
You have that on Washington Street? Excellent. That's going to be his home for the next few months. Mr. Pullins, when you graduate, I hope you do, from Hope House, you're going to go home to your family. You'll need to keep your probation officer posted. Hey, my new address is wherever that is.
Yes, sir.
Does your fiance have her own place?
Well, I haven't talked to her in like a couple of weeks, but last time I heard, she was staying with her family.
Okay, so family's helping her during, I mean, if she's due in a month, she needs support.
Yeah.
And she's got family around here?
Yes, sir.
How old is your fiance?
She's 52.
Okay. She's gonna have a kid at 52. Okay, I hope that goes well for everyone.
Yeah.
My goodness. All right, Ms. Davis, anything else in Mr. Pullins' case?
Your Honor.
Miracles. All right, that's it, Mr. Pullins. This is a sort of 8th chance for you. I hope it works.
Thank you, Your Honor.
Ms. Wood, we're going to bring Mr. Davis out for arraignment, unless you just want to, well, he should hear that we're waiving arraignment, but I needed to do the inmates because we got to get LT on his way.
And then we can do Mr. Stafford.
We'll go in whatever order you want, but I was asked to do the inmates first. And then we got to do Mr. Murf, but you said Mr. Stafford is a final plea hearing?
Yes.
Okay, we'll do that then, Mr. Murf.
I believe.
52.
Jackson made it to.
I hope.
Elijah Jackson, you here?
I think he's on Zoom.
Oh, he's on Zoom. Yes, all right, good.
Yes.
Yes, okay, you can go back on mute, just need to make sure you were here.
Elijah Jackson.
Oh. Okay. 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 Hold on.
We'll talk about that. You're just talking about scheduling right now. Right?
Okay, it's okay. Hey, Mr. Davis, give me 1 second.
Yes, sir.
Do you have the indictment number? I just tried looking it up.
It's
I don't have the trial calendar with me.
I just
How do you spell your first name?
DEMITR.
Oh, I got the wrong first name. So DEM.
Is DEMETRISTR.
Oh, Demetrius.
it's spelled wrong in
Oh.
Odyssey though, Judge. So the case number is 24SC
Ah,
006492-01.
okay, got it. You're right. It is spelled differently. Okay. Mr. Davis, you have been re-indicted. You've got the original charges, and then I know Ms. Wood had told you there was a new set of charges kind of floating around out there. The state just combined them all in one indictment. But because there's a new indictment, it's pretty similar to the old one, but it still is new. We just need to do your arraignment all over again.
Yes, sir.
And so Ms. Wood can waive arraignment on your behalf where she enters a not guilty plea, or we can do a formal arraignment where I read each charge into the record. And we're going to follow Ms. Wood's guidance on this as to what we're going to do. And then we're keeping your case on the trial calendar in case it's something that can work out. But Ms. Wood will let me know if she's already filed a motion to sever the counts because they're two different sets of allegations. And so her perspective as the legal expert on your team is that if you do go to trial, you should be tried for one set and then whatever happens with that one, be tried for the other set of allegations and not mush them all together. We'll have a hearing on that. But in the meantime, I just need to know if we're good to go forward with the indictment. And like I said, we'll keep your case on the trial calendar and see what happens with this motion and all that kind of stuff. Okay?
Yes, sir.
Ms. Wood, is Mr. Davis waiving arraignment?
Yes, Judge, I filed the waiver yesterday.
Okay, then we're all set, Mr. Davis. Ms. Wood will continue working with you. I know she's working very hard on your behalf to try to resolve the case short of trial.
Yes, sir.
She shared with me that it's not a particularly strong trial for you in terms of the evidence. In other words, the state has strong evidence. But I also know the stakes are very high. The state's not offering you probation.
Yes,
It's a pretty serious outcome for you, no matter how it goes, whether you go to trial, if it doesn't end well, or if you enter a plea. But Ms. Wood is moving forward with that. And I'll have you brought back here if there's some breakthrough and things are resolved. Otherwise, I know you are on a trial calendar that starts next Monday, but you're not on the first week of that trial calendar. The earliest you would go would be that second week, the week of the 18th. But it's not my calendar exclusively. It has cases from a bunch of judges. And so I wait in line until my case could go, but your case is my case on that calendar. And Ms. Wood knows that, and she'll be ready to go if it gets reached. But I also have a calendar here, and so Ms. Wood will be juggling those two things, and she'll let you know what's happening. Any questions about process?
I want, not really. I wanted to, know, do I still, when I come back, you said Monday?
So you will not be brought over next Monday. You might be brought over on the 18th if you make it onto the short list of cases for that second week of trial that your case is on.
So we will be going to trial?
Don't know. Don't know. You may. There'll be no surprises. Ms. Wood's going to let you know. You're not going to walk in here and there are going to be jurors sitting there. Ms. Wood will let you know. If you do go to trial, we'll get you a different set of clothes, all that kind of stuff. So I don't want you to panic. But if you are brought over on the 18th, that's a sign that you're on the short list for that week. Okay?
Okay.
We'll keep talking, okay?
Okay, yes, ma'am.
All right. Thank you.
All right. Thank you both. All right. And you had someone for whom we're just doing the,
Yes, Mr. Stafford, which is position number 6.
Mr. Stafford, come on up with your security vest.
And Judge, I have an updated offer on Mr. Jackson, so I'll step out after this and call him.
Okay. All right, let's get on the record in position 6, which is State versus Stafford, 25 SC 000644. Mr. Stafford, you are charged with burglary in the first degree in this case. Ms. Wood, do you have what you believe is all the discovery in the case?
I think I may be missing a couple of things if it exists at this point.
Okay, what kinds of things would those be?
A possible recorded conversation between the alleged victim and Mr. Stafford.
Okay,
Possible surveillance footage. It sounds like it could be from like a Ring security camera. And then receipts, if there are any, from the alleged damage.
got it. The alleged victim is male or female?
Female.
Female, Ms. Reeves. So it sounds like the things you described aren't necessarily, I mean, they're certainly not police generated things. So if the state has them, they got them from Ms. Reeves or whatever, certainly things you'd be entitled to if they're in the state's custody. Okay, it's interesting. There's a date range for the allegation. Okay. What is the state's offer, Ms. Davis, if Mr. Stafford were to go forward with a plea today?
The state's offer would be for 7 years, for him to serve. I want to say Mr. Stafford has served quite a bit of time in custody. It was about 277 days. So credit for all that time, the balance on probation, 40 hours community service, anger management, no contact with the victim, Ms. Reeves, and just to stay away from the location. So we're not at this time requesting any restitution. It would just primarily be community service and anger management, and to have no contact with the victim or go to her residence.
Okay. So I'm going to round it to around 9 months that he served in custody. So it would be 7 years to serve 9 months balance probated,
Yes, Judge.
plus those conditions.
Yes.
Okay. Mr. Stafford, do you understand what the state's recommending? If you were to enter a plea today, the state would recommend what is in effect a probated sentence. You'd not go back into custody. Your sentence would reflect that you were in custody for about 9 months.
I was in custody 21 months.
He was revoked on the basis of this case, Judge, and he did some time with the Department of Corrections.
Interesting. Revoked for a case out of Fulton?
Yes.
Who revoked you?
Dunaway, I believe.
Dunaway, yeah, Judge Eric Dunaway.
Okay. All right. You serve whatever time you served. We'll structure it to reflect all that, but you then be on probation. Bottom line is the state's recommendation is effectively probation. You understand that?
Yeah,
yes?
I understand.
Okay. You understand that today, if you entered a plea, you could withdraw that plea if the sentence I gave you was more than what Ms. Wood asked for on your behalf.
Yeah, I'm not going to enter a plea today, though.
Okay, well, you don't have to. I just want to make sure you understand these things so that when we're together on September 25th, you don't say, wait a minute, now they're offering me 2 years to serve. I want that deal back in August because that's their offer today. It may not be their offer tomorrow. It may get better. They may say, how about a misdemeanor? You could say yes or no to that. You always have the right to go to trial. You're not waiving that unless you enter a plea. So that's what we're teeing this up for then, would be a trial on that September trial calendar. If you decide to enter a plea sometime after today, you can do that, but you are, after today, losing that right to be able to withdraw from the plea if you don't like the sentence you get.
Yes,
okay? Any questions about that?
No, sir.
Where do you work security?
At First Place Hotel on Snapfingerwood.
Is it not a real safe hotel?
It's okay. I mean, ain't nothing happened since we've been working out there.
Who's we?
Me and all my brothers.
Okay. You're like the security detail at the hotel?
Yeah, all of us, yeah.
How did they hire all of your brothers at once?
The man who owned the security company, his twin brother is in the same prison with my dad, and that's how we found out about the
Okay,
job.
so you guys are connected in that way.
Mm-hmm.
Interesting. How many hours do you work there?
We work about 10 hours, 5 days a week.
Okay. Meaning you work 50 hours a week or you work 2 hours a day?
No, we work 50 hours a week.
It's a lot of security. Okay. Any questions about anything?
No, sir.
Let me check your bond and we'll go from there. I guess, Ms. Wood, who are you? Are you bugging Ms. Davis for this discovery, or are you hoping that Ms. Reeves is handing over that discovery?
I have not spoken to Ms. Reeves yet, but I've been bugging Ms. Davis.
Okay.
We'll keep working on it.
I didn't realize this. Okay, from back there, bond. All right, you're supposed to stay away from the address on Hapeville Road and stay away from Ms. Reeves. You able to keep doing that?
Yes, sir.
Okay, then you're all set. I will see you on September 25th. Did you get something in the mail telling you to be here?
Yes, sir.
All right, that address is still good?
Yes, sir.
All right, we'll see you on September 25th.
All right, thank you.
You're welcome. All right, let's get Mr. Murf up here, please.
Thank you.
And you can call Mr. Jackson. Hey, Mr. Jackson, Ms. Wood's going to be calling you, so I don't know if you've got a bunch of phones. If you don't, you may need to drop off this call and then get back on after you're done speaking with Ms. Wood, okay?
Okay.
Thank you.
And then we've got Mr. Jones, and I think that's it. We may have to bump one of these to after the lunch break, but we'll figure it out. All right. Ms. Davis, are you ready on Mr. Murf?
Ready.
Well, let's get on the record. 24 SC 002 938, State versus Nathan Murf. Mr. Murf is here in court. Ms. Kim, his lawyer, is online. Ms. Davis, representing the state, is here. Mr. Murf, before we get started, you have the right to have your lawyer by your side. Ms. Kim is working remotely today. Do you waive your right to have Ms. Kim by your side so we can go forward with the plea?
Yes.
Okay. She is available. She's going to be listening and talking on your behalf. If you need to speak with her privately, let me know. I'll let you step outside. You can call her up and you guys can have a confidential discussion. I don't think you'll need that, but that's not my call. That's yours.
All right.
So if we reach a point where like, wait a minute, I got to talk with my lawyer, just tell me, we pause, and you can get on the phone with her. Okay?
Yes.
All right. When you're ready, Ms. Davis.
Raise your right hand. Do you swear or affirm the testimony you should give in a matter before the court should be the whole truth and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Nathan Deshaun Murph.
At this time, are you under the influence of any alcohol, drugs, or a medication?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
I'm 41 years old, graduated in 2001.
Where did you go to school?
DM Thelma High.
What?
DM Thelma High.
Thel?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses: possession of oxycodone, possession of drug-related objects, failure to maintain lane, and failure to obey a traffic light?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Ms. Kim, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
And this is actually an accusation. Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Kim, do you waive formal reading of the accusation and any and all defects therein for the purposes of this plea?
For the purposes of this plea, yes.
Mr. Murf, do you remember having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Attorney Kim, do you know of any outstanding warrants related to this case?
No.
Mr. Murf, has your attorney advised you the minimum and maximum sentence for each charge to which you're pleading to today?
Yes.
For the possession of oxycodone, the maximum sentence is 15 years. For the possession of drug-related objects, the maximum sentence is 12 months. Failure to maintain lane and failure to obey traffic light are also 12 months.
Yes, but can I also say something? The oxycodone.
I need you to speak up a little bit.
The oxycodone.
Nathan. Do you want to just talk to me out to the side?
Sure.
Okay. So two things. One, you and Ms. Kim can discuss that in a second. When we're done hearing from Ms. Davis, if I end up accepting your plea, I'm going to ask you if there's anything you want to add. So you'll be free to add anything you want. And it may be, and I'm not saying this is what you're going to say, like, look, the oxycodone, there was actually a prescription. It was my uncle's prescription or who knows what. But if there's something you want to run by Ms. Kim, before you do share with me, you can do that. But we're going to press on with the state's presentation and then we'll pivot to yours. Okay?
Yes.
All right.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes.
You understand the court is not required to accept the state's recommended sentence?
Yes.
You understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
You understand that there are multiple charges to which you're pleading today and that the court has a right to run those sentences consecutively or one after the other?
Yes.
You understand if the court decides to order a sentence that differs from our negotiated plea that you're expecting, that you have the right to withdraw your plea?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in the accusation 24 SC 002938 to the count of possession of oxycodone, drug-related objects, failure to maintain lane, and failure to obey a traffic light?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
No.
Is-
Say again? Hold on a second.
Is it your decision today to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes at trial that the evidence would show on March 15th, 2024, officers with the South Fulton Police Department were conducting surveillance regarding tips they received about a Domino's pizza driver selling narcotics. That location was 2413 Roosevelt Highway in Fulton County, Georgia. Officers determined that the vehicle that was used to transport these narcotics was a Chevrolet Impala, which was registered to the defendant, Mr. Nathan Murf. He also matched the description from tipsters. Officer observed the Impala, and that Impala did fail to maintain a lane. It failed to stop at a red light, and officers initiated a traffic stop. They smelled the distinct odor of marijuana, and the officers conducted a search of the vehicle. They found what was confirmed by the GBI's vendor NMS, oxycodone, an amount of about 17 grams. Officers also located a grinder, suspected marijuana, which was not tested. The oxycodone was located in a pill bottle. It did have the defendant's name on it. It doesn't reveal if it did show that it was the actual substance on that pill bottle. But this was the individual that was consistent with the tips that they had received. They did indicate that a significant amount of the pills were missing. And so in light of the information provided, Mr. Murf does have a history, but in light of what we believe may be some challenges with this case, we are offering a probated sentence for Mr. Murf. It would be 5 years probation, no drugs, 60 hours community service, obtain his GED, and complete a job training or skills course.
You graduated from Thurl?
Yes.
Okay. You take care of the GED. So 5 years probation, 60 hours community service.
Correct.
Okay. When you refer elliptically to challenges with the case, just concerning the nature of the stop, or?
Yes.
Okay. I mean, running a red light.
Yes.
Okay.
Yes.
All right. It's your case. Ms. Kim, before I hear from you, Ms. Kim, Ms. Jackson, criminal history information on Mr. Murf. And I've seen the repeat offender notice from the state. So I've got 5 priors down here, mostly from '04, but all from DeKalb and Fulton. But you may have more.
I'll probably have the same. There are 19 cycles. The last arrest was January the 22nd, 2025, out of Fulton County for a probation violation. There are felony convictions, one in 2012 out of Clayton County for possession of a firearm by a convicted felon and possession of a firearm during commission of a felony. One in 2006 for possession of marijuana with the intent to distribute and trafficking ecstasy and obstruction of an officer. And there was one in 2009 for possession of marijuana with the intent to distribute. And there was one in 2004 for possession of marijuana with the intent to distribute. There's an additional one in 2004 for possession of a firearm by a convicted felon and possession of marijuana with the intent to distribute. So one misdemeanor conviction that was in 2017 out of Clayton County for battery family violence. Nothing in addition, Your Honor.
Thank you. Ms. Kim.
Judge, I wanted to ask my client, did you have any questions off the record you need to ask me?
No.
You're good?
Yeah, I'm good.
Okay. He says he's good.
Okay, Judge, my client is 41 years old, as he stated. He works 2 jobs. One is a Domino's delivery driver, and I believe he's wearing the shirt for the first job, and he's also a sanitation worker for a company called Valley Living. But Judge, he accepts the offer from the state, and we hope that you will go along with it as well. I'm hoping that you will give him a behavioral incentive date. I'm understanding he's on probation. If we could run that concurrent to this current case. It's here in Fulton County.
Okay. I'm going to talk with probation in just a sec. Anything else from you, Ms. Kim?
No, Judge.
Okay. Ms. Simpson, is Mr. Murf on probation? For what case?
C 11747.
All right. And did this case create a revocation event?
Yes.
Okay. So his plea isn't going to trigger another revocation. Okay. How much time is left on the 13 SC case?
Has 2 years, 1 month, 15 days remaining.
Okay.
Judge, one thing about it, he's also completed about 90 hours of community service, so I believe he's fulfilled that condition as well.
How did he complete 90 hours of community service in connection with this case? That was part of the revocation?
That was part of the prior case, I believe.
Okay, I'm not able to look at the prior case. It is listed as confidential in the system. It can't be a first offender. This would have been, was it a Judge Glanville case? It would be, because that's how Judge McAfee ended up with it. I can't get in the docket.
Judge McAfee signed a consent order in March of this year.
Okay. What were the conditions?
He did stipulate and is revoked 3 months when credit is not served. He was actually ordered to 500 hours of community service.
500.
And drug and alcohol eval, and any treatment, follow-up treatment. That was all in his order.
Do you remember that?
Yes.
500. Where are you doing your community service?
I actually, once a week, I donate like food or school supply because, like I said, I work 2 jobs, so I'm unable to come to the office and do community service, so I have to donate.
And how does that work? Like, if it's 2 pizzas, you get 10 hours?
No, I have to buy perishable items.
Okay.
Or school supplies and bring the receipt, and they give me credit.
And where do you bring them?
To the probation office.
Is there some probation officer who out of the back of his truck is selling fresh produce that you bring?
That's the program they have at the probation office now.
Have you heard of this, Ms. Simpson?
At Fulton County probation?
That you can, if community service is,
Yeah, because in fact, we just got an email about it, today. Our field office provides, where supervisors can do some of their community service hours there at the Atlanta office, because we opened up to serving the homeless there, and so it allows them to get some of that community service time.
Okay, well, what Mr. Murf is saying is a little different. It's that because he doesn't have the hours available, because he works 2 jobs, somehow he's able to help stock the food pantry there. And by making that contribution in kind, they'll say, all right, that's 5 hours.
They'll allow them, if they can't use what's on that list,
Uh-huh.
they'll allow them to participate into the hour, 1 hour community service program.
Okay. Well, that's helpful to know. I don't think I'm gonna add community service hours to the 500 that you are working down. What are you at now?
Like 92.
You have 92 left, or you've done 92?
Done 92.
All right. So you have 408 left.
Yeah.
Okay.
Just starting in March though.
What was this case from 2013? What were the kinds of charges? Do you remember?
Just possession. That's all I can remember.
More drugs?
Yes, sir.
Okay. All right. Somehow that didn't show up on the state's notice. Interesting. Okay. Mr. Murf, I find there's a factual basis for your plea. Your Impala and a Domino's driver had become of interest to the police based on tips. I'll note for the record, you are wearing a Domino's shirt here in court today, connecting you at least to that line of work. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we talked about. Voluntary means no one forced you to enter this plea. Do you agree with those things?
Yes.
All right. I'm sentencing you pursuant to the Probation Options Management Act, which means simply that while you're on probation, if you have a technical violation, and I'm making this up, but let's say you tested positive for marijuana, 1 positive drug screen doesn't mean you have to come back to see me. You and probation would figure out what the consequences of that would be. But if it's more significant, you get arrested again, anything like this, that comes back to me and we'll figure out what we're going to do with that. Ms. Kim, can someone in my office electronically sign the indictment for you?
Yes, Judge, thank you.
Ms. Davis?
Yes, Your Honor.
And Mr. Murf, is it okay if we electronically put your signature on the indictment for your guilty plea?
Yes.
We'll do that. So I am going to follow the negotiated resolution. Let me check one last thing. Okay. And I will sentence you to 5 years probation on count 1 and 12 months probation on counts 2, 3, and 4. They will all run concurrently with each other. That's it. No community service. You already got your high school degree, so you don't need a GED. What you really need to do is focus on sanitation and pizza delivery and not the 3rd line of work. Because I just think you're in South Fulton's crosshairs. They think you're in the mix. And if you get pulled over and you got something in your car, even if there are 3 other people in the car, they're going to say, ah, man, that must be Murph's stuff.
Okay.
This sentence will run concurrently with your 13 SC sentence. I guess I'm going to add this condition. Any community service that you do not complete in the 13 SC case rolls over into this case. So you have 500 hours left and you've got 2 years left in that probation. If we fast forward and I was doing what I could, but I still have 100 hours left, that case is going to close out and that balance slides over to this case.
Okay, good.
I'm not adding to it, but if you don't finish, I'm not encouraging you to slow down because probation in that other case may say, hey, you only have 6 months left. You've got 100 hours. You're going to need to, we're going to take out a warrant or who knows what. So this will be the backstop for that. Anything else, Ms. Davis?
No, Your Honor.
Okay. Ms. Simpson, Mr. Murf already has a probation officer. Do you need to give him any reporting instructions? What does he need to do?
Contact his current officer so that they can go with the conditions of this sentence.
Okay. Who's your officer?
Miss Do. Shoot, they be switching my office so many times. Cause newbie, yes, this newbie.
Okay. So you're gonna get some info about when you need to reach out to her to say, I'm back, new case, 5 more years together. And let her know that, okay?
Okay.
All right. Ms. Kim, anything else?
Judge, would you consider a behavioral incentive date to kind of?
I did consider it, but based on where we are and this other case and all that community service, I'm gonna leave things as is. And I'm hoping that Mr. Murph's done getting arrested.
I believe it is, Judge. I mean.
Okay, all right.
Thank you.
That's it.
May you be excused?
Yes, you both are excused.
Thank you.
Are you with him? You're gonna keep him out of trouble as best you can? All right, good luck. All right, I need to have us take a break now. Let's touch base about who's left.
Okay.
So Murf, Lee, Dunn, you guys have been very productive this morning. We have Mr. Jackson, and you had reached out to him. What's gonna happen with Mr. Jackson?
That'll be a negotiated.
Okay, and then we've got Mr. Jones, and I think that clears this calendar. Mr. Jones, you've been very patient, I appreciate that. I'm gonna have you go get some lunch, and we're gonna take your plea when you come back from lunch, because I gotta go to a meeting. Are you able to do that? All right, I appreciate it, but do come back. We wanna close this out today, all right? And same with Mr. Jackson. Is he able, he's welcome to stay on, but he could pop back. Why don't we try to be back here at 12:45? We've got the 1 o'clock calendar, but if we can get rolling with those two, please, that would be great. Anything I need to know from the one of these? Mr. Jordan working out his cases, Ms. Rios?
So the issue was I did not get discovery on some, because these are from drug court and I did not get the book. So I had one originally, then I just got a link just now for one of the cases and I'm still missing a link for one of the cases. So I don't think we can take a plea today.
Okay.
And then also, I believe he got kicked out of drug court. Is some confusion on
He did.
that.
I know Mr. Jordan. I'm asking because I know him and is he still in jail?
No, he's out.
Oh, he's out.
Supposed to be finding a program on his own.
Okay, he did. He was in drug court and he got this new burglary, position 3.
That's what we were figuring out. It's actually really old. It's a 2021.
Well, then position 2. One of these cases is something that he picked up a new burglary charge, which is how he got kicked out of drug court.
Okay.
He had a job, a great warehouse job. He lost the job, didn't have the heart to tell his family, acted like he was still going to work, needed to make money, and got back into this line of work. He's a super nice guy, kids. It doesn't mean he doesn't need to deal with his business. I'm just letting you, so I just was optimistic that maybe we could, but he's not in jail at least. So I'm still optimistic we can sort this out, but he's not burning a hole in a cell somewhere. He is out. Okay, well, I will see him at 1. And then Ms. Patrick, one of her cases went away. Are we resolving the other one?
We are, I just need to talk to, we're gonna pop over the.
Okay, I'm gonna get out of your hair. Those are the two questions. Oh, last one, Ms. Wood. Ms. Alexander was blowing our office phones up. Have you had a chance to talk to her? Sick kid?
Yes, the child is in the hospital. I'm just trying to get some documentation. I've spoken to her mom, so I was gonna ask that his
she was at Scottish Rite, got Monica, and like, I don't know what to do. And so I was gonna give you her number, but you've got it. And so, I didn't, if she was able to go home and this was work outable, she could just hop online, but, she should focus on her kid. Okay. All right, I'll see you guys a little before 1.
Just a point of clarification, the Patrick that you guys referenced for the no cross, was that Serita or was that Kiara?
So both, positions 7 and 8, that case is being no prossed. Ms. Clark announced that in an email to the lawyers and to me. So, but the Kiara has that other case, which is why I was asking. Yeah.
Because.
Yes.
Okay.
Yeah, but remind me when we get to that. And we need to hear Ms. Clark say, no pros, but, so Sarita, I don't know if she's gonna show up, but, that's been resolved and Kiara's number 7 has been resolved. All right?
Understood.
And then number 14 is off. We're having a motions hearing, but that's Ms. Clark's case. All right, I'll mute things in here. All right. Let's see. Turn that off. We're good. So we're back. Welcome back, everyone who was here this morning. We've got our calendar for this afternoon. We take quick attendance for this afternoon, and then we can do Mr. Jones's plea. I think, yep, Ms. Rios is right there. Is Michael Jordan here? There he is. How you doing, Mr. Jordan? Good to see you. Donnell Pierce. Not seeing him. No, he should be here. Mr. Pierce? All right, we'll give him a moment to see if he makes it. Make that notation. Aaron Nolan in custody. All right. Kiara Patrick. Hey, Ms. Patrick. How about Serita Patrick? Hey, Ms. Patrick. Your case, I think, is Ms. Clark. She's online. Hey, Ms. Clark, how are you?
I'm doing fine, Judge McBurney.
There we go. Are you, your plan is still to null pros or dismiss the case ending in 424, is that correct?
Yes, Your Honor, I've submitted a proposed order for your consideration.
Did that go to Ms.?
null pros the case.
Oh, there it is. Okay, great. So Serita, am I saying your first name correctly? Patrick, your case is being dismissed. You're welcome to stay if you want to, but that's it. That's your one case. Kiara, you have two cases. One of them, the one that you have with Serita, how are you guys related? Okay, auntie and niece are, that case is being dismissed, but Kiara Patrick, you've got one other case that's still open. We need to figure out what we're going to do with that, okay? So I need you to stay here. Serita Patrick, you're welcome to stay, but you're all done with your case. Okay, thank the prosecutor. Thank you. Okay, Craig Daniels. Mr. Monsiagli, I thought we had excused you and your client. You didn't get word of that?
Right, no, I decided to come down.
Oh.
He is on the Zoom.
Okay. Am I misremembering or did I excuse you? I could have sworn, didn't you have some request to, what am I misremembering?
No, at first I thought.
Oh, it was to get you off the trial calendar. Is that correct? You have leave? No?
No.
I'm thinking of the wrong case. Is Mr. Daniels in Illinois?
Yes.
And he drives all over the place and we had to modify his bond so he could be anywhere but Georgia?
That's right.
And I thought there's something that's changed about the schedule of this case. Did you not recently reach out to Ms. Nelson to say, could we?
The case was put on the November trial calendar except for instead of the September trial calendar?
That's where I guess I just noticed from the September trial calendar that it's just 1 week and Mr. Monsiagli's on leave for that week.
And that's perfect. Our announcements actually this morning is quick, so we can take care of it now if you are ready.
What is that announcement?
Judge, the state just got the results from the GBI and I served that on the defense. I also, upon receiving that, because it was kind of determinative in the case, I also served an offer because it was kind of just in the last literally day. The defendant wants more time to think about it. And since this case is not until November, I put an expiration date at the end of October. And so if we could just, preserve the defendant's final plea rights. And then once the defendant's made a decision, we will set the case for a plea if that's how it is going to shake out. or we will be here in November.
Okay, I don't see Mr. Daniels online. Maybe he's using someone else's name.
I'm not sure. He told me that he was waiting, but it might not be under his name.
Okay, there's a Gia Short, a Danikia Mann, and a Tamika Stone. Those are the only names on there that aren't people I recognize, none of which is Craig Daniels, but that could be.
I think Gia is the.
Yes, Ms. Short is the victim in this case.
Well, that's certainly not Mr. Daniels then. All right, why don't you track him down? He can join the call and we'll just close that loop that you almost completely closed. All right, Miranda Parks. Excellent. Danikia Mann is on the call. I saw that name. Good. Okay. And then Crystal Alexander, Ms. Wood. What are we doing with that? Are we, let me find number 12. She's on the September trial calendar. Are we just moving that to the trial calendar, but preserving her final plea rights?
That would be my request.
Okay, Ms. Davis, Ms. Alexander called my office this morning and ultimately got in touch with Ms. Wood. She was at Scottish Rite with her child who wasn't well and said, I'm here with the kid and can't leave. And I'm sure Ms. Wood will get documentation of that. But my staff spoke with Ms. Alexander and could hear in the background that the kid wasn't doing well. So I think we'll just preserve final plea rights and move Ms. Alexander's case to the trial calendar?
Yes, Judge.
Okay. Anything else on that case, Ms. Wood?
No, Your Honor, thank you.
All right, Donald Shorty.
He is in DOC custody.
Uh-oh, did we only learn that today?
No. I thought I saw it.
Oh, Deputy Gordon, is Donald Shorty here? Oh,
He's at Terrell County.
okay. Ms. Nelson, did you do a production order for Mr. Shorty?
I'll have to check. Where was he at?
He's at Terrell County Correctional Institution.
Terrell County Correctional Institution.
No, I did not.
Oh, how did you see a production order? Okay, maybe he's one of these popular guys. All right, so we have to reset that. Is your sense, Ms. Rios, that he's going to be in DOC custody for a while?
I think he gets out in January.
Oh, but over there, because we'll reset this just for a few weeks. He would be in DOC custody. Yeah. Okay. Was this something you and Ms. Davis had discussed that was resolvable if we could track him down?
Worked out. I talked to him on the phone.
All right, so we just need to get a Zoom link. Okay, for plea. All right, thank you. All right, that's it for this calendar. Anyone here from this afternoon calendar who didn't hear their name? Nope, that's it.
Mr. Daniels is on. I gave him the wrong number. I think it was for 9 o'clock.
Okay, there he is. Hey, Mr. Daniels, turn on your camera, please.
Hey, good afternoon.
There you are. All right. Mr. Daniels, as I understand it, the district attorney's office just received some forensic evidence from the GBI. And Ms. Nix, the prosecutor, has shared that with your lawyer, Mr. Monsiagli. He and you need to digest that. And did that evidence come with a new offer or now an offer because now you've got that evidence?
Now an offer.
Okay, but that offer was just yesterday or sometime this morning?
This morning, yes.
Okay, so that's something, Mr. Daniels, you and Mr. Monsiagli need to ponder. You are on, we had to move your case to the November trial calendar because of leave your lawyer has filed. You will need to be here, not in Illinois, on November 13th. for the call of the calendar, but if you and Mr. Monsiagli resolve this case with some negotiations before then, and it's appropriate, I don't mind there being a Zoom. But if it's to probation, probation has to start here, which means Mr. Daniels needs to be here. And obviously, if it's to custody, that's here as well. So I don't know that a Zoom plea to anything other than a suspended sentence makes a ton of sense.
Right, okay.
Okay, so that's a bunch of months for you to work through what you just received and talk with your client about it. If there is a non-trial resolution, no need to wait until November 13th, if we can do that. Mr. Daniels, do you have any questions about anything I just said?
No questions, no.
Ms. Nix, anything else? All right, I will preserve his final plea rights and we'll move it to that trial calendar. And if there's nothing else, you both are excused.
Thank you.
Thank you, Judge.
All right, bye. All right, Ms. Davis and Ms. Rios, are you ready for Mr. Jones's plea?
Yes.
And then Ms. Wood is, there he is, Mr. Jackson's on. Is he ready to go after we do Mr. Jones?
Yes, sir.
Great. Whenever you're ready.
Sorry, Judge.
That's okay. You said you are ready?
I'm ready.
Okay. All right, Ms. Rivers, are you ready to hit the record?
Yes, Judge, I'm ready.
Great. This is position 9 from this morning's calendar, State versus Willie Jones. Mr. Jones is at the podium with his lawyer, Ms. Rios. Ms. Davis is here for the state. It's indictment 25 SC 001 607, several counts of burglary in the second degree. Mr. Jones, in a moment, Ms. Davis will put you under oath, ask you some questions. You've heard those questions several times this morning. It's your turn to answer them. If you've got any questions of your own, will you let me know?
Yes, sir.
Okay, Ms. Davis?
Please raise your right hand. Do you swear or affirm that the testimony you will give in the matter before this court will be the whole truth and nothing but the truth?
Yes, ma'am.
Okay. Please state your true, correct, and legal name for the record.
Willie Frank Jones.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
40, high school.
And what high school did you attend?
George Washington Carver High School.
Did you graduate from high school?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses? Burglary in the second degree. There are 3 counts.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Jones, do you remember having been arrested on these charges?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Attorney Rios, are you aware of any outstanding warrants?
No.
Mr. Jones, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading to today?
Yes, ma'am.
Burglary in the second degree is a minimum of 1 year and a maximum of 5 years.
Yes, ma'am.
You understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court.
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
You understand that there are multiple charges to which you're pleading guilty today, and the court has a right to run those sentences consecutively or one after the other.
Yes.
Do you understand that if the court decides to order a sentence that differs from our negotiated plea, that you have the right to withdraw that plea?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else? Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 25 SC 001607 to burglary in the second degree?
Yes.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes at trial the evidence would show between the dates of July 3rd through July 5th, 2023, located at 173 Boulevard Street in Atlanta, Georgia, in Fulton County, that officers with CSX Railroad were alerted to a theft of some of their cars that were in the yard. There appeared to be damage to shipping containers. Their locks had been removed. Tires from inside of those shipping containers were stolen. There were microwaves that were also stolen as well. There is some surveillance footage and photographs of the individuals who were involved in this theft. At the time of July 5th, Mr. Jones, along with one of the other co-defendants in this case, was arrested on scene after they were alerted to a theft occurring on CSX property. We are extending the same offer that we did with the other co-defendants for this case. And we are recommending a probated sentence for Mr. Jones. That would be 5 years probation. Restitution, we will reserve that right, and we're still waiting on some documentation from CSX. An anti-theft course, 60 hours community service. He would need to complete his GED if he wasn't a graduate, but I believe Mr. Jones already indicated he is a graduate. And to stay away from all railroad yards for the duration of his probated sentence.
Got it. All right. I follow all that. Thank you. Good afternoon, Ms. Jackson. Do you have any criminal history information on file for Mr. Jones?
Yes, Your Honor, there are 12 cycles. The last arrest was July the 18th, 2025 in Henry County, Georgia, for driving while license suspended or revoked. There was no disposition for that arrest. Does appear to have an open case pending in Clayton County for driving while license suspended or revoked. And he appears to have an additional open case pending in Douglas County for cruelty to children in the 3rd degree. Nothing in addition, Your Honor.
All right. Ms. Rios, I didn't hear anything about convictions. Is this a first offender plea? Even though there are these other things in the works, not that any of these driving with license suspended will be felonies. I don't know about cruelty in the 3rd degree.
Misdemeanor too.
I think so too. Okay. So Mr. Jones is interested in first offender.
Yes, sir.
All right. What else do you want to tell me about him and this situation?
He is 40 years old. He currently works for AJ Towing. He's been there for 8 months. Prior to that, he was working at a body shop doing, working on cars. He has a 10-year-old. Oh, no, I'm sorry. He was doing that. I'm sorry. He has a 20-year-old and a 2-year-old. I'm also asking for a behavioral incentive day of 2 years, given that he's 40 years old and has never had a felony conviction before. I don't think this is going to be a continuous thing. And hopefully if he doesn't have any issues over those 2 years, he can be off probation.
Okay. Anything else? All right. Mr. Jones, you're working at a towing company now?
Yes, sir.
Is it your towing company or someone else's?
Someone else.
What do you do?
Just tow cars.
Okay. And what's the radius? Are you?
Flatbed operator.
Oh, it's a flatbed.
Yes, sir.
Okay. And what's the radius? Are you just in Fulton County? You all over Georgia?
Just about all over Georgia.
Okay. How long have you been doing the tow truck driving?
I got like 6 years experience in tow truck driving.
But this particular job with AJ Towing?
8 months.
8 months. How is it then that 4 weeks ago, 3 weeks ago, you got pulled over for having no license?
Didn't know, out the blue. I didn't know I had a failure to appear from 2019. So by being COVID coming around, they sent my case to the state without me knowing of a court date. So that's how I was in. I was doing body work down in Clayton County, just so happened coming back home for work and found out that my driver's license was suspended.
What's the status now?
I haven't.
It's back?
Yes, sir.
Okay.
I got it back the next 2 days.
Okay. Did you just owe a big fine, or what did you have to do to get it instated?
Yeah, I owe $350, but they just reinstated it.
But you still have to pay the $350?
Yes, sir.
And then the Clayton County case that's open, how old is that?
They were right a week behind each other. Couple days behind each other.
Both were in July.
Yes, sir. When I found out my driver's license suspended, I was trying to get back down and make money so I can get them off of the upon suspension, because I know it wasn't nothing like that, like as far as my driver's license being.
Okay. All right. In your household, do either of the kids live, the 20-year-old or the 2-year-old?
No.
2-year-old? Okay. And what county do you live in?
Fort.
All right. Tell me what you know about first offender. It's okay if you don't know anything about it, but.
Not too much.
So if I sentence you as a first offender, it means you don't have a conviction. You will have a sentence, but it's what we call first offender probation. So if you are looking to change jobs or do whatever, and you have to fill out a form, and one of the questions is, are you a convicted felon? Mm-hmm. The truthful answer is no, I am not, because this is not a conviction. It's the sentence that if you successfully complete, then it can come off your record. Okay. So you get one try at first offender. That's the benefit, is it's not a conviction. That helps with work if you want to go to school, anything like that.
Yeah.
It carries a risk. You're pleading to 3 counts of burglary in the 2nd degree, which if I stacked them, you'd have 15 years exposure. If you don't do well on first offender probation, by that I mean if you get arrested again for anything, whether it's driving on a suspended license or breaking into CSX rail cars or helping Mr. Lemons break into CSX rail cars, then we get back together and I can think about taking away your first offender status. And without a trial, you'd have a hearing, but not a trial. I could resentence you up to 15 years, 3 times 5. And then you would have a conviction and you'd have a much longer sentence. And I share that with you just so you understand the risk or the downside of first offender. If you are pretty sure that you aren't going to be getting into much serious trouble between now and 5 years from now, then first offender makes a ton of sense because it keeps your record pretty clean. But if you're not so sure what life is going to be like over the next few years, first offender could be a gamble. You need to make that decision, not me. Do you feel like you better understand what first offender is?
Yes, sir.
Do you want to be sentenced as a first offender?
Yes, sir.
Okay. All right. You have questions about anything else that we discussed?
No, sir.
Mr. Jones, oh, I have a question. How did you know Mr. Lemons?
I don't know.
So the other defendants in this case, you know any of the, I already met Mr. Wise. He told me why he doesn't know anyone in the case. And then there's someone who wasn't here today, Jairus Talbot. There are 4 people in the indictment. You, Lemons, Talbot, and Wise. You've never heard of any of those people?
Oh, man. I'm saying no, sir.
Okay. You got arrested, though, when these guys got arrested at the CSX rail yard?
I got arrested on the streets. So
Okay.
I wasn't really around anyone.
Okay. One of the guys who's already pled said, look, I knew what they were doing, but they basically paid me, I don't remember the money, I'm gonna make it up. They paid me $50 to basically just be watching to let them know if the police were coming. How were you connected, if at all, to these guys? Didn't even know them?
Not at all. I was just so happened to be parking my car on the backside of the rail yard.
Yeah.
And I was on apartment property. So when the officer did come around, he caught me on the apartment property.
Did you live at the pencil factory loft?
No, sir. Visiting.
Visiting someone?
Yes, sir.
Okay, and you just happened to be parking at the wrong time?
Yes, sir.
And did you tell the officer, like, I don't even know what you're doing
I
here?
told him he didn't care about it.
Okay. All right. Is this an offered plea, Ms. Rios? Or you and Mr. Jones? I don't want to get into your private conversations with him. Just
We can do it under Alfred. I mean, we didn't discuss Alfred but we can do it under Alfred.
we don't have to do it any way other than how you want it to go. I'm just trying to process what Mr. Jones is saying, and that may be different from what he told you. I'm not putting him on the spot. I'm just trying to figure out who knew Mr. Lemons and who didn't know Mr. Lemons. And the fact that he was in the body shop and this and that, Mr. Lemons was into working on cars too.
If I could have 1 minute to explain what Alfred is, if he wants to take it.
Sure. Okay. Why don't you check with him?
We would like to move forward and he'll do it under Alfred.
Okay. So, Mr. Jones, an offered plea simply means, hey, it's in my best interest to work this case out. I don't want to run the risk of going to trial, and who knows what these other guys would say I had to do with it. And so I'd rather work this out, even though I don't necessarily agree with everything the state says happened. Is that your situation?
Sir.
Okay, then I'll accept it as an offered plea. I'll also sentence you as a first offender. I do find there's a factual basis. I'm hearing your version. I've heard some of what the CSX officers had to say as well. And I also find that your plea is knowing and voluntary, knowing meaning you've understood all the things people have been saying in our conversation, and voluntary meaning on your own, with advice of a lawyer, you've decided this is what you want to do. Do you agree with all that?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act so that while you're on probation, if you have a minor probation violation, like maybe you don't return your officer's call right away or something, you and probation can sort that out. But if it's more serious, you get arrested for anything, you're driving without a valid license, that all comes back to me. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Davis?
Yes, Your Honor.
And Mr. Jones, can we sign for you?
Yes, sir.
Done. We will table restitution for now, and I will follow the negotiated resolution, Mr. Jones, sentencing you to 5 years on counts 1, 2, and 3. Those will all run concurrently, and that will be probated. Special condition of probation number 1 is that you complete an anti-theft course. Number 2 is 60 hours of community service, and you need to have completed at least 20 of those in the first 3 months of probation. And number 3, I think if I'm counting correctly, is that you stay away from all railroad yards. But it doesn't sound like you're in the line of work where you'd ever need to be on a rail yard. Okay. And I will set a behavioral incentive date of 8 and 6 is 14, February 6th of 2027. That's right. No, 2028, February 6th of 2028, which is 2.5 years from now. So if you have done everything you need to do and stayed out of trouble and driven with a valid license, then probation can ask me to close out your probation early. All right? Ms. Davis, anything else on behalf of the state?
No, Your Honor.
Ms. Rios?
Mayor.
Mr. Jones, Ms. Simpson, who is seated there in the jury box, is with probation. She's going to give you reporting instructions. The probation office for Fulton County is right down the street on Memorial Drive, and you're going to need to be there on a certain day at a certain time. She'll tell you that. Don't miss that, because if you miss it, they just bring me a warrant saying this Jones guy's already up to no good. That's a bad way to start first offender probation. Okay? Any questions about anything? This is your chance.
No, sir.
Okay, good luck with everything. Ms. Simpson? Or you're just going to chat with him? Okay. Why don't you get on the record what his reporting date and time is?
So your reporting date be Monday, August the 11th at 8 a.m. Yes.
Yeah, this next Monday. All right. And then she's got more info for you, but we're done. All right. Did you know that was Julian Terry sitting in court yesterday the whole time?
No.
That's the code. They came together. They were hanging out. So that guy, I thought it was some kin, but no.
That was back there.
Yeah. Well, yes, there was. And so it may have been like, hey, watch my other daughter.
Wow.
Yep, gathering intel.
Oh, we had to get judges together.
So we're going to do Mr. Jackson next when you are ready as the plea machine that you are.
At the wrong calendar.
All right, let's get
Sergeant,
Ms.
1%.
Wood and, hey, Elijah Jackson, if you could turn your camera on now, please. I'm going to take care of your case. There you are. Are you driving a car right now or just sitting in a car?
I'm parked. I'm just sitting in the car.
Okay. That's a perfectly fine place to be, especially if it's raining. Let me know when you're ready.
Oh, sorry, Judge, I'm ready.
Oh, okay, great. I'm ready too. All right, Ms. Rivers, we're going to get on the record with position 5 from this morning's calendar, last position. 24 SC 006 274, State versus Jackson. Mr. Jackson is appearing from his, is that your car you're in or someone else's car?
It's mine.
Okay. Appearing from in his car, which is parked. Ms. Wood is appearing virtually, and Ms. Davis is here in court. Mr. Jackson, before Ms. Davis can get started, I need you to let me know that you are comfortable going forward in this setting. You have a right to be here in court, but you also can waive that right and appear from the driver's seat of your car. Are you okay doing that?
Yes. Yes, sir.
You also have the right to have Ms. Wood, your lawyer, right there sitting in the passenger seat so that you guys could talk if you had any questions, but she is not in the passenger seat of your car. She's somewhere else. Are you okay with that setup?
Yes, sir.
If you need to speak with her privately, just let me know and I can put you guys in a breakout room where you can have a confidential conversation. All right?
Okay.
Ms. Davis.
Mr. Jackson, please raise your right hand. Do you swear or affirm the testimony you will give in this matter before the court will be the whole truth and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Elijah Caleb Jackson.
And can you spell Elijah for us?
Elijah.
Are you under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 19 and I'm in high school. That's how far I've gone in high school.
Are you still in high school or did you stop?
No, I stopped.
How far did you go?
I don't have my GED or I just stopped going to school like in 12th grade.
Okay, so you almost graduated, but not quite.
Yes.
Where did you go to high school?
I went to Frederick Douglass High School.
All right, thank you.
And did you say you obtained your GED?
No.
Okay, just want to clarify. Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses? And Judge, we are going to be reducing the fleeing to a reckless driving.
Okay.
Okay. And so you are charged with a theft by receiving, possession of a firearm during a felony, and reckless driving.
Do you happen to have the code provision for reckless driving?
I do, Judge.
All right.
It is.
Oh, I can look it up. If you don't have it written down, you keep doing your thing.
Get written down, Judge, but I do have it really quick. It's not going to take but a second. That would be 40-6-390.
390. All right.
I actually have it written, but just didn't see it. Okay.
Okay.
So, Mr. Jackson, are you aware that those are the charges that you're facing today?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes.
Attorney Wood, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
We do.
Mr. Jackson, do you remember having been arrested on these charges?
Yes.
Judge, the state is unaware of any outstanding warrants related to these charges. Attorney Wood, are you aware of any outstanding warrants related to these charges?
I am not.
Mr. Jackson, has your attorney advised you the minimum and maximum sentence for each charge to which you are pleading?
Yes, ma'am.
For the theft by receiving, it's a minimum 1 year, max 5 years. For the firearm during the commission of a felony, it is 5 years consecutive. And for reckless driving, it is 12 months. Do you understand that?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has a right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively, or one after the
Yes.
other? Do you understand if the court decides to order a sentence that differs from our negotiated plea, that you have the right to withdraw that plea?
Yes.
And Ms. Wood, is Mr. Jackson taking this plea under first offender?
Yes.
Okay, so I will go through that as well. Mr. Jackson, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty to or nolo to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for a crime, felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction? You
I'm
were
sorry, I
breaking-
didn't understand what you said.
Oh, I thought my phone broke out. The internet bad over here.
I'll
Okay.
repeat. Do you understand that you
But
may
it's
have,
back now.
okay, do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 24 SC 006274 to theft by receiving, possession of a firearm during a felony, and reckless driving?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes at trial the evidence would show that on September 2nd, 2023, officers with the Georgia State Patrol and Atlanta Police Department were participating in a joint crime suppression detail in the area of Holmes and Hollowell Parkway. When they were attempting to get gas at a station at that location, they observed a Hyundai Elantra with the rear window bust out. Officers also observed there were individuals in the car who appeared to be juveniles wearing hoods and masks. The officers followed the vehicle. At first, the vehicle began to travel very slowly. They activated their emergency equipment, and the vehicle did drive at a high rate of speed. Ultimately, Georgia State Patrol performed a pit maneuver and was able to disable the vehicle. It kind of flipped on Collier Road. They were able to detain 3 of the occupants on scene. They captured another person who had run away. All of the individuals in the vehicle were minors or juveniles, except for the driver, who is Mr. Jackson. Officers did recover a gun that was located in a driver's bag. With that being said, Mr. Jackson does not have a criminal history here. He is very young, and so the state is recommending a probated sentence with certain conditions. We are recommending a 5-year sentence. I believe it actually would have to be a 6-year sentence because the possession of a firearm during a felony is 5 years consecutive. So it would be a 6-year sentence on probation. Mr. Jackson will be required to obtain his GED, to complete 60 hours of community service. He'll be required to forfeit that firearm. He will need to complete a job training course, skills course, or participate in at promise, any one of those options, but some sort of course to be able to provide him a better footing in life. And he is to have no contact with the co-defendants who were taken through the juvenile process, and that would be Mr. Bird, Fambro, and a Mrs. Brown.
All right. Can you be sure to email those names to Ms. Nelson so we get them in the sentence? Great.
And nothing further from the state.
Okay. Ms. Jackson, do you have any adult criminal history information for Mr. Jackson?
There are 3 cycles. The last arrest was March the 19th, 2025 in Fulton County for a failure to appear. There are no convictions listed in the GCIC, Honor. Nothing in addition.
Thank you. Ms. Wood?
Thank you, Judge. So Mr. Jackson is 19 years old. He served collectively 62 days for this case, so we would ask that the court take note of that. He's currently working as a delivery driver, and I spoke with him and his mother over the lunch break. They're both very eager for him to hopefully get his GED as well as possibly a trade. We are asking for the court to consider waiving probation fees for a period of time. They are trying to get a more stable living situation together. And so they're working very diligently on that. But if we could just waive some of those probation fees, I think that would be helpful. And we are asking for first offender treatment. And I have told him, but I want to just put on the record, he has an ankle monitor. I will help make sure that he gets that removed. And I think they were concerned about another ankle monitor compliance calendar. He just had an appointment with Judge Manning a few weeks ago. And so I told him he should not have to go back in front of the court for ankle monitor compliance because it will come off. But I told him we would discuss that with the judge.
Got it. Okay, well, I'll start with that first. He did have a compliance hearing on July 21st. Clearly it went okay because here he is. The only other item on the docket right now is the trial calendar in September, but that's moot because he's entering a plea. And so, Mr. Jackson, what you will be able to do as sometime this week, I bet, once I sign your final disposition or sentence, Ms. Wood can get you a copy of that, and you take that to Second Chance, and they'll take the monitor off your ankle.
Okay.
Do you know where their offices
Can you
are?
repeat? No. Can you repeat that because my phone is breaking up?
Sure, it's important that you hear what we're talking about. When we're done here today, there's a document that I'm going to sign. It's basically your sentence. Ms. Wood will get a copy of that. She will get it to you. You take that document to the bonding company, the electronic monitoring company, and that's all they need to see in order to take the monitor off your ankle. Okay?
Okay.
All right.
Do you know what company it's through?
Yeah, it's
Is it
called
Second Chance?
A Second Chance. If you look them up online, it's going to have their address. Call that number saying, "Hey, I need to get my ankle monitor removed," and they will tell you where to go. And you just have to bring your sentence with you. And they see that, and they know you're done with your case, and they'll take the ankle monitor off.
Okay.
All right. Do you have your driver's license with you?
Yes.
Can you hold it up to your phone so I can see it?
It might be in the back, like in the trunk.
Pardon me?
Well, I got to get it out the trunk.
That's all right. You didn't have your license suspended because of this situation with the Georgia State Patrol?
No, I didn't have a license then.
Oh, you didn't have a license then,
Yeah.
but you have one now,
Yes.
which is good since you're a delivery driver. Okay. And did the car actually flip over?
Yes.
Like it was upside down?
Yeah. He said no. It was if he said it flipped 2 times, but it landed back on his wheels.
Okay. So when you got out, you didn't have to like climb out the windshield or something. You just opened the door.
Nah, he had to he pulled me out because I got tased, like, and my door wasn't open, and I guess he pulled the door open, and after he tased me, he pulled me out.
Okay. You weren't one of the guys who ran away.
No.
Okay. All right. Do you have questions about anything we discussed?
No.
When you say delivery driver, actually, Ms. Wood said delivery driver. Does that mean you do DoorDash or you drive a UPS truck or what is it you do?
I'm working in my car, and it's an app called Roadie, so I signed up, and they let me start the same day. But it's something like UPS, like where I go get the boxes and stuff and just deliver them. So I pick it up from a warehouse.
Yep.
Yeah, I drop it off.
All right. How long you been doing that?
For about like 6 months.
You make good money?
Yeah, it's good.
Okay. First offender is an opportunity for you, Mr. Jackson, because you have no felonies on your history. And if you do well while you're under sentence here, this case goes away effectively. It does not stay on your record. It does not affect your ability to go back to school or get other jobs. That's the good part of first offender. If you mess up while you're on first offender, and by mess up, I mean you get arrested again because you're rolling in a car with those 3 knuckleheads, or you run from the police, or you've got a gun or something like that, because you cannot have a gun while you're a first offender, that's going to blow your first offender up. You'll come back in here, we'll have a hearing, and the state may ask me to resentence you, and based on what you pled to, it looks like I've got 11 years to work with. And I say that not for you to be scared of me or anything like that. You probably think I'm just this funny old guy. But you need to know there are consequences if you're not so sure over the next 4 or 5 years that you can stay out of trouble. And you may be certain that you can stay out of trouble, and your mom may help you do that. But I want to make sure you understand that if you don't, then it gets messy pretty quickly for a first offender. Do you understand that?
Yes.
Understanding that, understanding how old you are and the choices you need to make and your ability to make those choices Do you want to be sentenced as a first offender? You think that's a safe thing?
Yes.
Okay, well, it's your call. I will sentence you as a first offender. I find there's a factual basis for your plea, and that your plea is knowing and voluntary, meaning you've understood what we've been talking about and you feel like you've made this decision of your own free will. No one forced you to do that. Do you agree with that?
Yes.
I'm sentencing you under the Probation Options Management Act so that while you're on probation, if you have a real small violation of probation, you and probation will resolve that. But if it's more serious, you get arrested again, something like that, that comes back to me. Ms. Wood, can someone in my office sign the indictment for you? Ms. Davis, can someone sign for you?
Yes, Judge.
And Mr. Jackson, since you're hanging out in your car rather than here in the courtroom, is it okay if we sign the indictment for you?
Yes.
We'll do that. I'm going to sentence you on count 1 to 5 years to serve 2 months with a balance on probation, and you'll get credit for the time you, nope, I'm sorry. I'm sentencing you to 1 year to serve 2 months with the balance on probation. Count 2 has to be 5 years and has to be consecutive. And count 3 is 2 months to serve. Those are all going to run concurrently with each other. So your total sentence is 6 years to serve 2 months with a balance on probation. Special condition number 1 is that you're going to get your GED. It sounds like you were pretty close to graduating and then you punched out. But you do need to get your GED. And in fact, you need to show your probation officer proof of enrollment in a GED program within the first 6 months of your probation. Special condition number 2 is that you'll complete 60 hours of community service. No contact with any of the other defendants in your case, Mr. Bird or those other 2. I will waive your probation supervision fees for the first 6 months. And then the last special condition of your probation is that you need to enroll in either job training or you can start your GED at an at-promise center. There are several of them around Atlanta, but you're going to want to get yourself to an at-promise center and let them know that you need to do some programming there, either the GED programming there or job training program. Okay?
Okay.
Questions about that?
No.
Ms. Wood, anything else on behalf of Mr. Oh, and there were some things seized from that car, and you are forfeiting those. So if you were going to say, hey, wait, I want one of those guns back, not this time. Those guns will be forfeited. Okay?
Okay.
Ms. Wood, anything else?
I just shared probation reporting instructions via text. So if he could check the phone after we log off.
Okay. Ms. Davis, anything else?
No, Your Honor.
Mr. Jackson, what county do you live in?
Fulton.
Okay. What's your zip code?
You gave me old. Yeah, 30034.
Okay. Somehow he already has reporting instructions?
His residence is not stable.
Mhm.
And so therefore, his reporting is just going to be reported within 48 hours.
Okay, and that's what Ms. Wood already sent? Okay, great. So check your phone, Mr. Jackson, when you are off with this, and that's going to tell you when you need to get to probation and where probation is, okay?
Okay.
If you got any questions about any of that, just reach out to Ms. Wood. She will help you through it, okay?
Okay.
Any questions for me?
No.
All right. Any questions from the other person in the car for me?
I guess I was asking Miss Woods about, I didn't understand the terminology of 1 year of probation and 2 months.
So the first count of the that Mr. Jackson pled to, the sentence is 1 year to serve 2 months with the balance on probation. So that's 10 months of probation. Mr. Jackson already served the 2 months. He's not going to have to go back to jail, but he's getting credit for that. His sentence is reflecting that he needed to do 2 months in custody for driving this stolen car real fast, crashing it, all that kind of stuff. But he already did the 2 months. So that means he's got 5 years and 10 months of probation.
Oh, okay.
All right. Anything else?
Oh, thank you.
You're welcome. That's it, Mr. Jackson. You're good to go.
Okay.
All right. So pivoting to this afternoon's calendar, Mr. Jordan, you're up first. And it's my understanding that Ms. Rios, your lawyer, still needs to get some discovery. A couple of your cases are kind of old, and she needs to get the paperwork related to it, police reports, et cetera, so she can give you her best advice about what to do with those cases. Is that a fair statement, Ms. Rios?
Yes, Your Honor, and he's working on trying to get into the STAND program.
In a stand?
Get into the STAND program,
Mhm.
so he's in the process of starting that.
Okay. Does that provide residential support, or it's more, what does stand get you?
It's an outpatient program.
Outpatient treatment?
Yeah.
Okay. All right. So his cases, all three, are on the September trial calendar. Is that enough time, you think, to get your arms around the discovery?
I think they just sent me one, I think I only have one left. But can we do a inquiry calendar in the early,
I'm open to whatever. My thought is we leave it on, this September trial calendar is a month and 20 days away.
Yeah, I didn't realize it was the end of September.
Yeah.
That should be fine.
Okay, and we'll preserve Mr. Jordan's final plea rights. It seems like a resolvable situation, but it takes the state and the defense for that to be the case. Which case do you not have discovery for?
Trying to figure out which one they sent me on. I for sure had it on number 3. And then I think I was just sent number 1. I think I'm just missing number 2. Yeah, I'm just missing discovering the one ending in 6.
Okay. Ms. Davis, I know right now we're doing other things, but is recreating discovery for something like position 2, is that a complicated thing, or?
I'm making a list from today of folks who need discovery.
Okay.
So, yeah, just adding all 3 to the list just to triple check, because there is a discrepancy in the dates. I'm not quite sure anything is fairly recent on the recent number, so we are going to work on that.
Got it. Okay. Any issues with keeping this on the trial calendar, preserving Mr. Jordan's final plea rights?
No, Your Honor.
All right, Mr. Jordan, you have any questions about anything we've been discussing?
No, sir.
Who did you bring with you?
Girlfriend, Samantha.
Hi, Miss Samantha. How are you doing?
All right.
How long have you known Mr. Jordan? All right. So far, so good? Mr. Jordan, how is it? Is it your daughter? You have a kid?
Yeah.
Daughter?
2.
2. How are they?
They good. One just graduated high school, going to Fort Valley.
Fantastic. Congratulations. That's big. Were you able to go to her graduation?
Yes.
Okay. And so she starts Fort Valley, what, in just a couple weeks? Today.
Yes, I hope that will.
Oh, you're a bad dad. All right. You're going to help her move in over the weekend. Okay. Well, congratulations on that. All right. Well, if there are no other questions, do you have good contact information for Mr. Jordan?
Yes, sir.
Do we have a good address for you? Did you get something in the mail to be here?
Yes, sir.
Okay. Don't be scarce. We'll see you on September 25th at the latest to see what's happening with your cases. Okay. Did I say September? I meant to say September.
Yes.
Good. Okay. All right. That's it. All right, Donnell Pierce, last call. We will do a bench warrant for him. You want to make a note of that?
Oh, yes.
Okay.
The board already listed for him.
All right, excellent. Aaron Nolan in custody. Ms. Rios, what are we doing with Aaron Nolan?
We are ready on a negotiated plea.
Okay. And how about Kiara Patrick?
We are also ready on a negotiated.
All right. Then Kiara Patrick's other case was dismissed. Same with Serita Patrick. Craig Daniels, we already dealt with. Miranda Parks.
That is also a negotiated plea.
It is, but Judge, I have a question, because this may be.
Do you want to
my fault.
introduce yourself to everyone?
I'm ADA Jasmine Willingham. I'm coming back, or I'm back now. Judge, I believe that we may not be ready to do the plea today, but I wanted to ask you
It's a
about
bad
it.
start for you.
I know.
Yeah.
It is negotiated still. However, when I looked, I kind of remembered that the possession of a firearm could not be reduced, but then I read it and I thought I was wrong about that. But I'm back to, I think I cannot reduce it. So I think I need to accuse the case, which is fine. It doesn't change the terms of it or anything. I just need to get that accusation done.
So I'm not going to get too much up in your business, but is it not, I don't have the indictment in front of me. It's not the standard possession of a firearm during the commission of a felony?
It is.
Which would be would be +5.
Right.
Right.
It's, the case would be, the offer is all misdemeanors.
Got it.
And it cannot be reduced to misdemeanors under under 1710.5, possession of a firearm during the commission can't be reduced to misdemeanors. At least that's my understanding. But I did tell Ms. Rios I would ask you, because if you look at it and you see it differently, then I'm fine doing the plea today. I just want to make sure that we don't.
Want a legal plea, correct. And plan B would be to, is the reason why you wouldn't just null pros count 2 is that your view is more than 12 months probation.
Correct.
But you're okay with misdemeanors?
Yes.
Because plan C would be, all right, then how about 2 years probation to felony aggravated assault? But the negotiations were, let's reduce these to misdemeanors. Correct. But you would need multiple misdemeanors to get past 12 months.
Yes.
Okay, I'm gonna look at 1710.5 while we're doing stuff. Thank you for flagging that. I appreciate that. And still welcome back. How about Ms. Mann? I think it's Ms. Mann, position 11?
I think she's on the Zoom.
Oh, she is. There she is on her front porch. Okay, she's here. What are we doing with that case, Ms. Wood?
Just a final plea hearing.
Okay. Do we know who has it for the state?
Yes, Ms. Clark.
Ms. Clark. Okay. All right. And that's it for the calendar. So my proposal is we do Ms. Mann first. That'll be quick. And then we'll do Ms. Patrick. And while we're doing Ms. Patrick, I'll look at 1710.5 so we can figure out what we're going to do with Ms. Parks. And then we can do Aaron Nolan. All right. So Ms. Mann, I'm going to get you on the screen here. There you are. And we need to get Ms. Clark on the screen. There she is. We can take this off temporarily. All right. So let's get on the record with position 11. It's 25 SC 000934, State versus Mann. Ms. Mann is appearing virtually along with her lawyer, Ms. Wood, as is Ms. Clark. I'm the only one in court. Ms. Wood, do you have what you believe to be all the discovery in Ms. Mann's case?
Yes, Judge.
Okay. Ms. Mann, you're charged with 3 counts of cruelty to children in the 1st degree. Ms. Clark, if Ms. Mann wanted to resolve the case today, what is it that the state would be recommending?
Your Honor, the state's recommendation would be, 10 years, 10 years, with a behavioral incentive date of 4 years upon, special conditions of completion of the, Family First, program, as well as, and all of the required, trainings and counselings that are offered through that program. It's at no cost to the defendant, and, nonviolent contact with the victim child, and also the victim child's paternal grandmother, Miss Tamika Stone.
So 10 years probation, but after 4 years of everything going smoothly, the behavioral incentive date could kick in. And then the main special condition would be complete the Family First program to include all the associated counseling, et cetera.
Yes, Your Honor.
Okay, I got that. Makes sense. Ms. Mann, do you feel like you understand what the state's recommendation is in your case?
Yes, Your Honor, I do, but I feel like my case was already closed with defects. I've completed several classes, multiple drug tests. I did a lot of, I can't remember the classes that I did, but some of the classes, well, one of them was behavior class. I did management and some more other classes. So the stuff that the state is asking me to do, I've already done that with defects. On top of this, I was enrolled in school and working. I got unenrolled in school from 4K and get a decent job because it's different on my record. So I was honestly asking for the case to be dismissed.
Okay.
Everything that they're asking me to do, I've already completed with defects.
Got it. Well, I appreciate you sharing that. And I didn't ask my question well. I wasn't asking you so much, hey, do you think it's a reasonable sentence? I just want to make sure you understood it. It sounds like you do. I have a different question. Do you have a way of getting documentation of proof that you did all these many classes through DFACS?
Yes, I could contact defects. As of now, my attorney do have the letter from defects saying that the case has been closed with me doing all of those classes and everything. She do have that paperwork, but I will have to contact the defects caseworker, or probably even just try to get away up there to the office and get information for you.
Okay. Well, the more you can get your hands on, the better, because no one's interested in making you do the same kind of coursework twice. It sounds like you've already done some important work and you ought to get credit for that. But you'll need to get some kind of proof, a certificate or a letter from DFAC saying, hey, Ms. Mann did X and Y and Z, and you should work with Ms. Wood on that. In the meantime, it sounds like you're not interested in the current format of the state's recommendation. Is that correct?
Yes, sir.
Okay. Then what I'm going to do is move your case to our trial calendar. It's on the September trial calendar, so you'll need to come to court on September 25th, but you'll get notice of that. Ms. Wood will be talking to you about that. If you haven't resolved your case before then, we'll need you to come on in for the trial calendar, okay?
Okay. Could I get a morning time, because my kids are in school, so I want to make sure I'm able to get to court and able to get them from school.
So if you talk with Ms. Wood about what your schedule looks like in terms of getting your kids to school, she can let me know, and I'm making these times up, but she might say, hey, Ms. Mann's going to be here, but it won't be till 10 because she's getting her kids to school. You need to be there the day that you're directed to be here, but I'm okay if you get here a little bit after we start, if it's because you're getting your kids off to school.
Okay.
How many kids do you have?
I have 3 little girls.
What does little mean?
I have a 6-year-old, I have a 5-year-old, and I have a 2-year-old.
Those are little girls. The 6-year-old should be in school.
Yeah, she's in school. The 5-year-old's also in school, and the 2-year-old has been in daycare since she was 6 months, so she's in daycare too. But
okay, excellent. Where does the 6-year-old go to school?
She goes to school in South Fulton. at Seaborn Lee Elementary School.
Okay. Well, good. All right, Ms. Wood, anything else on behalf of Ms. Mann?
No, Your Honor, thank you.
Ms. Clark, anything on behalf of the state?
No, Your Honor.
All right, so Ms. Mann, along with taking care of all those kids, get to work on finding some documentation that you took all those classes, okay?
I will. Thank you, Your Honor.
All right, you guys take care.
Judge McBurney, may I be excused?
Yes, ma'am.
All right, thank you. All right.
You're welcome. All right, so I think we said we would do Kiara Patrick now. Ms. Patrick, if you'll come on up to the podium, please.
Judge, if we're able to do the plea, can I do it from my office? I need to call a victim.
Yep, just pop on the Zoom.
I will.
You're ready?
Yes, Judge.
Okay, Ms. Rios, you good?
Yes, sir.
All right, we'll get on the record position 6 from our afternoon calendar, 24 SC 006 277, State versus Kiara Patrick, who is here in court with Ms. Rios, Ms. Davis for the state. Ms. Patrick, Ms. Davis is about to put you under oath and she's going to ask you a bunch of questions about you and your case. You need to answer those truthfully and completely, but you also need to let Ms. Rios or me know if you've got any questions. Will you do that? Okay. And you got to speak up. So Ms. Rivers, that's our court reporter. She may look invisible, but she's trying to listen to what's going on. So make sure you project into that microphone, okay?
Okay.
Okay, great. Ms. Davis.
Please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Kiara Patrick.
Can you spell your first name for the record?
Kiera.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
I'm 24. I graduated from Miller Grove High School.
Where's that?
Is in Decatur on Miller Road.
Okay.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses? 1 count of aggravated assault and possession of a firearm during the commission of a felony.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
Yes.
Ms. Patrick, do you remember having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to this, to these charges. Attorney Rios, are you aware of any outstanding warrants related to these charges?
No.
Ms. Patrick, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
That's what we did when I called you. Yes.
For aggravated assault, the maximum is 20 years, and for possession of a firearm during the commission of a felony, it is 5 years consecutive. Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge? Do you understand that there are multiple charges to which you're pleading guilty today, and the court has a right to run those sentences consecutively or one after the other? Do you understand that if the court decides to order a sentence that differs from our negotiated plea, you have the right to withdraw that plea?
Yes.
I'm just going to ask you to speak up just a little bit for Ms. Rivers. Attorney Rios, is your client intending to take this plea under first offender?
Yes.
Ms. Patrick, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty to or nolo to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for a crime, felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony which can carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Excuse me,
You can't.
didn't get a response.
Oh.
The right to appeal after a trial.
Can you respond to, do you understand that this may impact your right to appeal if convicted of these charges after a trial?
Yes.
I'm going to ask you to speak it just a little bit more. Okay. I'm sorry. Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 24 SC 006277, aggravated assault and possession of a firearm during the commission of a felony?
Guilty on the offer.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
The Alfred plea.
Just confirm.
Yes.
So that's not a trick question. No one's trying to slip you up, but we're just going through some routine things. You know what it means to plead under Alford? Meaning you're saying, I know the state says this is what happened, that you pointed a gun at Ms. Weems, et cetera. And as I understand it, when you say Alford plea, you're saying that's not exactly what happened. I want to plead guilty. I don't want to go to trial, but I don't agree with everything. Actually, Ms. Davis hasn't said what the state thinks happened, but I just took a quick look at the indictment. You're charged with pointing a gun at Ms. Weems. But we're going to both hear what Ms. Davis says she thinks the evidence is. But it sounds like based on what Ms. Rios has told you, your view is that's not really how it went down, but I still want to work this case out. Is that a fair statement? Yes? Okay. That's what an Alford plea is.
Thank you, Judge.
You're welcome.
Are you entering this plea freely, voluntarily, given with the full knowledge of the charges against you?
Yes.
Judge, the state believes at trial, the evidence would show that on May 30th, 2023, at 1991 DeLoe Drive in Atlanta, Georgia, in Fulton County, that the defendant did arrive to the victim, Ms. Akiria Weems' residence. This is an apartment complex. They were engaged in a verbal altercation. It had something to do with their child's father. And that altercation escalated, and that the defendant did produce a firearm and point it at Ms. Weems. And it was because of this that she was charged with aggravated assault and possession of a firearm during a felony.
All right.
The state's recommendation, based on Ms. Patrick's limited history, is a recommendation of a total of 6 years probation. So that would be a 1-year sentence on the aggravated assault, with 5 years consecutive for the possession of a firearm during the commission of a felony. It would be a probated sentence. Ms. Patrick would need to complete anger management, 40 hours of community service, no contact with the victim, and we are, of course, not opposed to first offender.
All right. I think I got that. Ms. Jackson, do you have criminal history information on Ms. Patrick?
Yes, Your Honor. There are 5 cycles. The last arrest was March the 22nd, 2023 out of Lithonia, Georgia, for a failure to appear. The underlying charge was not listed. She does have misdemeanor convictions. It's one in 2024 out of DeKalb County for theft by taking, and one in 2023 out of DeKalb County for theft by shoplifting. Nothing in addition, Your Honor.
Thank you. Ms. Rios, Ms. Weems and Ms. Patrick have kids through the same person?
Yes.
Okay, got it. What do you want to tell me about Ms. Patrick and this situation?
Yes, Your Honor. Ms. Patrick is 24 years old. She works for a caregiving company. She has a 2-year-old autistic daughter and a 7-year-old son. I'm asking for this case to be treated under first offender and for you to consider possibly concealing the case up front, just because based on these charges, it might affect her caregiving work. I'm not sure, but that's what we're asking for, and a behavioral incentive date of 2 years, considering that she doesn't have any felony convictions. In regards to this case, I've watched the video and I didn't see anyone. There were several videos, so possibly could have missed it, but when I was looking through the videos, I didn't see her at any point like raise and point a gun at anyone. Now there might have been something in her hand that I couldn't really make out, but nothing, I didn't see her like point it at. So that's the basis for her Alfred plea.
Okay. So she's not saying she wasn't there or that she and Ms. Weems weren't kind of going at it. She's saying, I didn't bring a gun to this situation, or at least point a gun at it. Okay. All right. Appreciate you sharing that. Ms. Patrick, are both your children with this same guy who was the source of friction with Ms. Weems?
No, it was a miscarriage.
Oh, I'm sorry. So you ended up not having a child with what's this guy's last name, just so I can use a name?
Nelson.
Nelson. So you and Mr. Nelson ended up not having a child.
Right.
But Ms. Weems has a kid with Mr. Nelson.
Yes. Yes, I think.
I thought that's what the issue was with you and Ms. Weems, is that no? Why were you and Ms. Weems having a dispute?
It's about him, but
About Mr. Nelson, but not necessarily about the kids. It's just, hey, that's my guy. No, that's my guy.
right.
Okay. Are you still
No.
in Mr. Nelson's life, or is he in your life?
No.
No. Okay. That's probably better. Did you know Ms. Weems in any other way, or just because she was another in the Nelson harem?
No, like I used to see her all the time, but I never knew who she was.
Okay. But did you see her because of Mr. Nelson, or just you guys lived in the same apartment complex? Where would
I
you?
used to see her all the time.
Okay. But you don't see her much now.
No.
So staying away won't be difficult.
Right.
Okay. All right. Who lives in your household?
I stay with my mom.
Okay. And what about your kids? Do they stay with you? So it's you, your daughter, your son, and your mom?
Yes.
No one else?
My little sisters. I got two little sisters, a 18-year-old and a 9-year-old.
18 and 9?
Mm-hmm.
Okay. And you finished high school at Miller Grove?
Yes.
Tell me what it means to be a caregiver. What do you do?
Like I have different locations. I changed my clients. I do a lot for them. Like,
But like, what's an example? Like you go to their house or you go to an assisted living facility?
I go to most of my client house, but
All right. So you go to a house on Walnut Street, knock on the door. There's Ms. So-and-so who's your client.
yes, I go in there and bathe them, get them out of bed. It's like a Hoyer. I pull it. I get them out of bed. I feed them. I get them their medication.
Okay, so you take care of them. I mean, you're effectively a nurse for them. And how many clients do you have?
4.
Do you have them because they just found you online or you work for an agency?
A company.
Okay. How long have you been doing that?
6 years. In October, it'll be 7.
Wow, you started early. Okay, all with this same company?
No, I've been with 3 companies already, but now I work 2 of them. But one of them, I'm not currently working because I don't have transportation. So
What
I'm at
happened to
one
transportation?
company. My auntie back here was taking me to work, but she don't have a car right now. So
Okay. All right. Do you have any questions about anything we discussed?
no.
Tell me why this is an offered plea, not because you and Ms. Weems didn't get at it. You're saying there was no gun or you didn't point the gun or what's your version?
Okay. Basically, Miss Wing came to my house first. I got evidence that she came to my house first.
Okay.
And 2 days later, I went to her house.
And her house is the Delow Drive apartment?
Yes.
Okay.
And
you went to her house, you were bringing her cookies saying, I'm sorry, we had an argument?
no.
That's not why you went there.
Right.
Okay.
But
Were
I
you pretty
did-
hot when you went there?
Mhm.
Okay.
I didn't point at a gun, but I did have one in my hand.
Okay. How'd you get the gun?
It's in my name. I got it.
Pardon me?
I bought it from the store. It's
Oh.
in my name.
Oh, like you just went to a gun store and bought the gun?
I've been had it.
Pardon me?
I had been had the gun.
Okay. As a first offender, you can't have a gun anymore. I don't know if Ms. Rios told you that, but I'm telling you. So if you have one in your household, it has to go out.
Yeah, it's stolen now, so I don't have it.
Okay, well, don't get another one while you're on first offender probation. Because that's a whole separate crime and there's no second offender. So if you get pulled over and you got a gun in the car, that's a crime. So just be thoughtful about that. Well, I appreciate you sharing that. First offender is something you qualify for. It's a benefit. It means that this will not go on your criminal history because it's not a conviction. You will be under sentence for a while, and so you have to comply with the sentence. And while you're under sentence, you can't have a gun. That was one of the things I mentioned. But when the sentence is done, this can be expunged from your record, and it's as if nothing happened, except that you were under sentence and all that. So if you wanted to get a gun, you could. You can vote, you can be on a jury, all that kind of stuff. But while you're under sentence, if you get arrested for something else, not only do you have those new charges, whether it's theft by taking or shoplifting or whatever it is, but your first offender can kind of blow up on you. And you are pleading to 2 counts where if you add them up, it's 25 years. And so I'm just going to give you an example. I'm not saying it's going to happen, but you and Ms. Weems, for whatever reason, get back at it. Mr. Nelson's back in your life, but he's in her life. You get angry and you go over there with a knife instead of a gun. That's another aggravated assault. So you'd have the new charges, but we'd be back here and I'd say, Ms. Patrick, you made me think you're this caregiver and you're a good mom and all that stuff, but here you are getting hot and bringing a knife to someone. Not only do you have the new charges, with this old situation, I could revoke a bunch of your time, take away the first offender. All of a sudden, you've got the conviction, and I can resentence you. I'm not sentencing you to any jail now, but I could resentence you to some time. That means you're away from your kids, away from all this stuff, and then you've got a conviction. And I share that just so you understand There's a downside to first offender. It's mostly good. It's a great idea as long as you're pretty sure that you are going to handle things differently as you move forward in life. Do you feel like you understand the risk and the benefit of first offender?
Yes,
Do you want to be sentenced as a first offender?
yes.
Okay. Well, Ms. Patrick, I find there's a factual basis for your plea. Sounds like you had a gun. You insist you didn't point it. But if Ms. Weems came in and told the jury, oh, she did point it, and maybe another witness who's her friend says who pointed it, they might believe them. That doesn't mean that's what happened, but that may be who they believe. So I understand why you are entering an offered plea and why you're entering a plea and not going to trial. I also find that your plea is knowing and voluntary. Knowing means you've understood everything, and voluntary means no one's forcing you or making you to enter this plea. Is that true?
Mhm.
Yes?
Yes.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. While you're on probation, if you have a real small violation, you and probation will sort that out. But if it's a bigger deal, you get arrested for anything, that comes back to me. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Davis?
Yes, Your Honor.
And Ms. Patrick, can we sign the indictment indicating your first offender offered plea in this case?
Yes.
All right. Let me check one thing here on your case. What happened? You had a more recent case where you were arrested for stalking and disorderly conduct and things like that. It was in May of last year. Is that just still floating around out there? Did that go away? Or do you know what I'm talking about?
It's still on. Basically, I gotta go to court.
If you still have to go to court? Okay, I see the other one that got dismissed today. Those are two different things, although it looks like you got booked in at the same time for both those. But as far as you know, you still have to go to court. Those others are all misdemeanors. So, but you're keeping track of that.
Yes.
Okay, all right. Just want to make sure you didn't think everything is done through this plea today. All right, so Ms. Patrick, count one, I'm sentencing you to 1 year. Count two has to be 5 years, has to be consecutive. I will probate all that, so it's 6 years probation. Special condition of probation number one is no contact with Ms. Weems. Don't go near her. Don't put something online saying, if I see you again, I'm not going to miss you next time. 40 hours of community service and an anger management course. I will set a behavioral incentive date, which means if by that date you've done those requirements, community service, anger management, and you've been good to the probation people, you haven't been a pain, they are fully authorized to say, let's just close this early. Ms. Patrick is squared away. We got to focus on the people who aren't squared away. And that behavioral incentive date is August 6th of 2028, so 3 years from now. So you can cut your sentence in half if everything is going smoothly, okay? And Ms. Rios, if you want to submit a proposed order that would seal the docket for Ms. Patrick, just run that by Ms. Davis, and if she has no objection, let me know, and I'll look at that.
Thank you, Your Honor.
You're welcome. Ms. Patrick, any questions about anything?
No.
Tell me your zip code.
30310.
Okay. Ms. Simpson, who's with probation, is going to give you reporting instructions. Don't miss your first date with your probation officer, okay?
Okay.
Ms. Davis, anything else?
No, Your Honor.
Then we're all done.
Thank you.
But don't leave, you got to talk, or Ms. Simpson, you're going to talk to her, or she should come to you?
Go ahead and put her reporting date.
Yes, let's do that. What is her reporting date?
Your reporting is going to be August the 13th at 8 a.m.
So it's next Wednesday, 8 a.m.
It's not, it says, it goes, this is the way ours goes. So they're just gonna say no. So yeah, they just say no. And if the answer is no, then I just go to these next two questions.
Judge, minor example.
I just go to.
Sarita, yeah, I'll do that. Oh, you have a bench warrant. I'm just setting it aside. You missed court at some point? I don't know. You don't need to worry about it because they dismissed your case. So we'll do that.
Either way.
770-905-0224.
Just checking to see if you guys can hear me. My sound didn't work this morning.
Yes, ma'am, we can hear you. I'm just doing a little more research on your question.
Okay, thank you.
You're welcome. What's up?
Did his attorney apply for some type of psychological?
I sent you an email about that.
Right, that's why I just was trying to.
So we need to have under the new law that just went into effect, anytime someone requests a competency evaluation, we have to have a hearing. It can be perfunctory. Anyone have an issue with that? Nope, no issue. Great, then we do it. But we don't just get the request and then I sign them.
That includes the defendant being here.
Right.
I was trying to wonder if I actually need to take on that September trial.
It may not work out because, well, if in fact I need to do the eval, he'll have to come off the calendar. He's on the Emerson calendar for next week. But with that request out there, I just need to see him soon so we can have the hearing. It's odd. I mean, I've interacted with the guy several times. I don't see it. And so I worry it's a little bit of a delay thing, but we'll have the hearing.
So you prefer to handle that hearing rather than Emerson? So.
Correct.
Something.
Yeah. I'm not putting it
Want
that.
it before he's on the calendar for Emerson's next.
He will not be for next week. He is on that calendar, but we're far enough down. It won't happen next Monday.
So I need to schedule for September 26th.
Yes, please. So, Ms. Willingham, can you hear me?
Yes, Judge.
So I'm curious, Ms. Rios, you should listen. I got a question well, I think it's Ms. Rios. About Ms. Park's situation. I'm curious if, because we've had these charges before and there was a way to turn them into 2 misdemeanors, if that was the will of the parties. And I believe, that, one way to, make that happen would be you reduce aggravated assault to disorderly conduct and you reduce possession of a firearm during the commission of a felony to pointing a pistol at another, which is a misdemeanor. And then you've got 2 misdemeanors. And then you've got the framework you need to build the sentence you're interested in. It keeps the gun in the mix. It's just instead of possession of a firearm during the commission of a felony, it's that misdemeanor pointing a pistol at another, and the aggravated assault becomes disorderly. I'm not trying to make your meal. I've just given you some other menu options, and you and Ms. Rios can talk about that. But if Ms. Parks was open to it and she's here and ready to roll, my thought is let's act while we can.
Judge, that works for me. That's why I wanted to pose it to you. When I read it, I wasn't sure how to do it, but I am perfectly fine with that. So, count 1 would have to be the disorderly, and then count 2, you said pointing a firearm?
Pistol. It's called pointing a gun or pistol at another. It's 16-11-102. It's a misdemeanor.
Okay. All right. Well, then we should be ready to go.
Ms. Rios, why don't you chat with Ms. Parks about that real briefly? Because I don't know if that's what you had in mind or different.
A little different, but I think it will be fine. I'll just.
Okay. Why don't you guys talk? And then if that's going to work, we'll do that. And then we can do Mr. Nolan. What a day.
I scared you at first though, didn't I?
Yeah, it's like, nah, I didn't talk with that lawyer. Now I see why you didn't talk with that lawyer.
I was focused on the public defender.
Amen.
I kind of slipped my mind. There's other attorneys
But
that did not email, but I did talk to the public defender.
Target-rich environment is where you started.
Yes. Yeah. We had been in talks, so.
We had been in talks.
You're ready to move this.
All right.
Oh, man. Blackers, please.
May 26, 1981.
You in trouble?
Nah, something going on at 5A. So Colonel finna come here, he's gonna go to 5A.
5A or E?
A. Crowd control.
Wonder what he has today.
I just asked him about that.
Crowd control. Oh, this may be the day he has a sentencing.
Something about sentencing.
Yeah, guy is pumping gas and he's been robbed before. He keeps a gun on him, lawfully has a gun. He's pumping gas, gets in his car, and is gonna leave. And another guy, kid in a hoodie, walks up and starts to get in his car on the passenger side. Turns out he had gone in the store and identical cars at two different pumps. And he's going back to what he thinks is his girlfriend's car, but it's this guy's car. Opens the door 4 times. Boom, 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 boom. Kills him. Stays, doesn't run. Like, oh my God, I thought you were going to rob me. I had no idea. Because this guy's getting in his car. And he didn't think, shoots him dead 4 times. Girlfriend's there. Like, what did you do? Oh my gosh, you killed my boyfriend. What do you do? State has reduced it from murder to voluntary. State's recommending 5-ish, 10. He's saying probation. I was defending myself. I'm otherwise a good guy, cleanish record. Family of the deceased wants 1,000 years. So there's drama on both sides. No one is a winner in that situation. 4 shots though. One shot, baby. I'm bored.
I accidentally go to people's cars all the time. I think it's like, I need to be more careful.
I do that too. I
Yeah.
do too.
Right.
And I'd be like, why is this not?
Well, and that's why the guy didn't go to trial. Because he could say himself, but there'd be too many jurors like, I've done that before. I shouldn't get shot 4 times.
That's probably why he's done.
Be interested to hear what we talked about. Like, what do you do? How do you sentence that? So we'll find out. All right. Didn't mean to leave you up there, Ms. Parks. Let's make sure we've got everyone we need. We do. There's Ms. Willingham, and Ms. Rios will be right back. So let's get started. This is position 10. It's 25 SC 000906, State versus Parks. Ms. Parks is at the podium with her lawyer, Ms. Rios, and the long lost but now back Ms. Willingham is joining us from her office. Is that the same office or did you get upgraded to a better office or downgraded to like a basement?
Well, Judge, our entire unit is moved over to a different part of the building. And I have a window now, so I consider it an upgrade.
I was going to say, it looks like bright light. It doesn't seem like a downgrade. Is it in the Slayton building or it's in a different building?
No, we are in the government center now.
All right. Well, welcome back. Ms. Parks, in a moment, Ms. Willingham will put you under oath and then ask you questions that are very similar to what you heard other people answering today. But they'll be your questions, so make sure you listen to them carefully and answer truthfully. And if at any point you have questions of your own, let Ms. Rios or me know. Will you do that?
Yes.
Okay, Ms. Willingham?
Okay. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true and correct legal name.
Miranda Selena Parks.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
I'm 44. And I have been to two technical college where I attained my cosmetology license and medical billing and coding.
So you have a high school diploma and several technical certifications.
Mm-hmm.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you are charged with the following offenses on the indictment? Aggravated assault, family violence, and possession of a firearm during the commission of a felony?
Yes.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Counsel, are you satisfied that your client has a full understanding of the proceedings?
Yes.
And have you reviewed the indictment in this case?
Yes.
Do you waive formal reading of the indictment?
Yes.
Has your client been arrested on these charges?
Yes.
And Your Honor, the state is unaware of any outstanding warrants related to these charges. Counsel, do you know of any outstanding warrants that are related to these charges?
No.
Okay, and Ms. Parks, do you understand you are entering a guilty plea to the following offenses?
Yes.
This,
I'm sorry.
it's okay. Disorderly conduct under OCGA 16-11-39 and pointing a pistol under 16-11-102.
Yes.
Okay, and I'm sorry, both of those have mandatory minimums of 1 day and a maximum of 12 months. Has your attorney advised you of these minimum and maximum sentences for each charge you are pleading to?
Yes.
And do you understand that it is the negotiated plea, that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 24 months probation total. It would be 12 months probation for count 1 and 12 months probation for count 2, and that would run consecutive to count 1. You would be required to complete the family violence intervention program, complete 100 hours of community service, have no contact outside of any pending family court proceedings with the victim in this case. And is that what was explained to you by your attorney?
Yes.
Are you aware that the court does not have to accept that recommendation, and the court can sentence you up to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes.
Do you understand that if you do not accept the court's sentence, you may withdraw your plea, as this case is appearing on the final plea for today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment?
Yes.
And do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to the court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of disorderly conduct?
Guilty.
And how do you plead to the charge of pointing a pistol?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes.
Do you understand that you have only 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, should this case proceed to trial, the state would expect to show that on December 10th, 2023 at 2423 Martin Luther King Jr. Drive, Southwest Apartment 2307, Teresa Nelson and her wife, Miranda Parks, had an argument that turned physical. The day prior, officers had been called and separated the two, but Parks returned to the apartment around 3 a.m. because she had nowhere else to go. Parks began screaming at Nelson and then pulled out a pistol and charged at Nelson. They scuffled into the hallway and the gun discharged towards the outer wall. After the gun went off, Parks gathered some personal items and Nelson's phone and left the scene. Nelson complained of shoulder pain and she had a red scratch on her chest and small scratches on her face. Nelson noted they had been married for 2 years and had lived in this apartment for 1 year. She did not know where Parks could be. She stated Parks was secretive and Nelson didn't know Parks even had a job until recently. Near the front entrance, officers recovered a shell casing and a live round outside the apartment near the stairs. Your Honor, I've also had an opportunity to speak with Ms. Nelson in this case, and she stated that she's perfectly fine with the state's offer. She just wants this to be over. She actually made sure that we did include the no contact outside of family court proceedings because she does not want a no contact order to create an issue with them moving forward in their separation.
Got it. Okay, that answers one of the questions I had. Thank you so much. Ms. Jackson, is there any criminal history information on file for Ms. Parks?
There are 6 cycles. The last arrest was June the 18th, 2019 out of Clayton County for a probation violation. There's 1 misdemeanor sentence that was in 2017. She received a nolo contendere sentence out of Lake City, Georgia for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. Ms. Parks, where's Lake City?
Forest Park.
Oh, is that the same thing or it's a suburb?
It's the same thing, but like you go up the street a little bit, then before you get the South Lake Mall, it's Lake City right there.
Okay. Ms. Rios.
Yes, Your Honor. Ms. Parks is 44 years old. As you heard, she has her completed technical college. She was working at a Heritage Academy as a counselor and a mentor. Right now, she's unemployed. I'm asking for you to go along with the negotiated plea and do a behavioral incentive day of 12 months if she gets all the conditions completed.
Okay. Ms. Parks, anything you want to add?
I just want this to be over with so I can just go back on with my life. You know, I was teaching at the time, so I'm just trying to get back to that and try to get this over with.
Okay. Do you have a place to stay now?
Yes,
Okay. And where is that? What county is that in?
Clayton County.
Clayton County? All right. And you've stayed away from Ms. Nelson other than going to court?
Yes,
Are your divorce proceedings in Clayton or Fulton?
we haven't discussed that yet.
You haven't had to go to court?
We haven't.
Other than for this case, you haven't had to go to court for any divorce case?
No.
But you two are married?
Yes.
Okay, but it sounds like you're very separated right now because you're not supposed to have contact with her.
Right.
Okay. All right. Do you know where she's living?
I guess she's staying in the same place.
All right,
But
but if
she has
she's-
been trying to contact me. She, been texting my phone and stuff like that. So, I mean, I haven't responded back to her.
Good. That's sort of how it needs to be, other than if she's reaching out to say, hey, I need you to sign some papers, or do you both want the relationship to formally end?
I mean,
Kind of a heavy question, but if the way the prosecutors described this, eventually you all will need to be in court for there to be a divorce.
Right.
But there's not that's gonna take a while if Ms. Nelson's trying to make the relationship work. That's not consistent with the sentence you're getting, because you're not supposed to be around Ms. Nelson.
That's right.
Um,
So I'm looking forward to, after this, I'm trying to, we need to sign some divorce paperwork. She
Okay.
says she has, papers or whatever.
Got it. That type of contact is okay if it's related to how do we wrap this up?
Right,
Okay. You are both trying to do it without lawyers?
yes.
Okay.
I got one more thing. My dad got sick, and so, I'm probably gonna have to be relocating to Milledgeville, Georgia to take care of him. I just need to know if I was to be put on probation or have to do community service, can I be able to do that in Milledgeville, because I'm the only one he got, nobody else can do it for him right now.
So your dad's lucky he's got you, and I hope you're going to be able to figure out a way to take care of him, but maybe also do some work. There's nothing wrong with you being in Milledgeville. What you need to do is let probation know when your address is changing. You will not have to drive up here once a month to meet with probation. They have telephonic reporting, and they'll let you know how you can do community service down in Milledgeville and get credit for that. It's all about documentation. So if you're, I'm making up as an example, working at a church's soup kitchen, helping serve meals or something for folks who need those, there's someone there who runs that who will say, hey, you were here for 5 hours. Here's a piece of paper. It says Ms. Parks was here for 5 hours. You just want to make sure that the work you're doing on a community service basis is work that the probation folks approve of. And by that, I don't mean, we don't like Methodists, we only like Presbyterians. They wouldn't draw that distinction. They would just say, you can't work for a family business. It's not community service if you're mowing your own lawn. It would not be community service taking care of your father. That's important work, not community service. So you just want to clear it with them in advance, and then they'd want to know how you document it. But Milledgeville may need to be where you are.
Yes, sir.
All right, good question. Well, Ms. Parks, I find there's a factual basis for your plea. You and Ms. Nelson were into it, and it got out of hand. I'm glad no one got hurt. I also find that your plea is knowing and voluntary, meaning you've understood what we've been talking about, other than the one question you had, and that no one's forced you to enter this plea. Do you agree with that?
Yes.
All right. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Willingham, can we sign for you?
Yes, Your Honor.
We haven't signed that name in a long time. I hope Ms. Nelson remembers how to spell it. Ms. Parks, is it okay if we sign your name to the indictment?
Yes.
Great. So what I'm going to do, Ms. Parks, is sentence you on count 1, which has been reduced to disorderly conduct, to 2 months to serve, but you're going to get credit for the time you already served, which was 72 days. And count 2, I'm sentencing you to 12 months to serve. You, during those 12 months, need to complete a family violence intervention program. That's a bunch of courses. It's not like one class, but it's a number of weeks. And you'll need to have enrolled in that family violence intervention program within the first month of your probation. They offer that around the state. You don't need to worry if you move to Milledgeville. They've got that down there as well. It's not just an Atlanta thing. You'll also need to complete 100 hours of community service and no contact with Ms. Nelson outside of moving forward with the divorce. What county were you all married in?
Cobb.
Okay. I don't do family law, so I don't know if that means the divorce has to be in Cobb or if it's in one of the counties where you guys live, because you're going to be a completely different county if you move off to Milledgeville. But you will be able to interact with Ms. Nelson if it's in connection with getting the divorce.
Okay.
Ms. Rios, anything else on behalf of Ms. Parks?
No, Your Honor. Thank you.
Ms. Willingham, anything on behalf of the state?
Judge, I heard you say on count 2, 12 months to serve. I would assume that meant 12 months probation, but I just wanted to make sure the record was clear.
Thank you. Been a lot of pleas today. 2 months to serve. I know I said that on count 1. Count 2 is 12 months to serve, but it is on probation. It's 12 months probation. So you got a whole year to take care of these requirements. Thank you for clearing that up. Ms. Parks, if you could turn around one last time. You will get reporting instructions for probation either directly if Ms. Rios has given probation your contact information, or they'll contact Ms. Rios and then she'll put you in touch with them. But make sure if it's a phone call or an email or whatever it is that you respond, so they know that you are engaging with them.
Okay.
Because otherwise they'll send me something a few weeks in saying we can't find this person, and we got to start with a warrant and go from there. Okay? All right.
Thank you.
You're welcome. Thanks, Ms. Willingham.
Thank you, Judge.
Bye.
See you tomorrow.
Look who's here just in time for our inmate. Everything in control on 5A? Yeah. I was telling Gordon about that sentencing. It's a messy case. Oh, it's people speaking. He hasn't actually said, here's what I'm going to do. It's family and stuff.
That's a tough one.
Okay, thank you. Appreciate it. Would you mind if I use the bathroom real quick?
I don't. Hey, Mr. Nolan, he needs you over here.
Shut down.
No, oh, I should leave it open for the 4 o'clock? Okay, we got one more plea. And then we'll take a little break and then we'll do that.
Thank you for your email. You're welcome. Appreciate it.
What more than they got? Yeah. No, other guy, AG. No. Yeah, I had a good start off with. Yeah, well, I'll probably be on Instagram tonight. I just have to sit down.
All set?
Yes, Judge.
Okay, last plea of the day. Position 5, 24 SC 005-576. State versus Nolan. Mr. Nolan's in court with Ms. Rios, along with Ms. Davis, the prosecutor. Mr. Nolan, how you doing?
I'm doing all right.
Good. Ms. Davis is going to put you under oath in just a moment and then ask you a bunch of questions about your rights and about your case. Please answer those questions fully and truthfully. And then also let me or Ms. Rios know if you have questions of your own. Will you do that?
Okay.
Okay, sounds like a plan. Let's go.
Mr. Nolan, please raise your right hand. Do you swear or affirm that the testimony that you're giving before this court will be the whole truth and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true and correct legal name.
Aaron Nolan.
Can you spell Aaron for the record?
ARRIN.
2 R's?
Yes.
Okay.
Are you under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 31 and I graduated high school.
Where
That's
did
it.
you attend high school?
And I did it online, Penn Foster.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses? You're charged with criminal damage to property and possession of a firearm by a convicted felon.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Nolan, do you remember having been arrested on these charges?
Yes.
Judge, the state is unaware of any outstanding warrants related to these charges. Attorney Rios, are you aware of any outstanding warrants related to these charges?
No.
Mr. Nolan, has your attorney advised you of the minimum and maximum sentence for each of the charges to which you're pleading guilty today?
Yes.
For criminal damage, it is a misdemeanor. The maximum sentence would be 12 months. For possession of a firearm by a convicted felon, I believe it's 1 year to 10 years max.
Did you reduce the criminal damage, or I haven't looked at the indictment yet. I was looking at the time he's been in, but I don't think criminal damage to property in the second degree is a misdemeanor.
My apologies, Judge. Let me just
I'm pretty sure that's 1 to 5. If it's, but I'm looking at the calendar and not the indictment. I'm about to pull the indictment up.
Total 1 to 5. I thought it was a felony too.
Okay.
It is,
Thank
yeah,
you.
yeah,
Okay, my
yeah.
apologies.
So he went to town on a car. Okay,
So that'll be 1 to 5 years of the criminal damage and 1 to 10 for the firearm.
110 for the fire.
Maximum sentence.
Okay.
Okay, maximum and minimums. Do you understand that?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that you are charged with multiple offenses? And so the court can run those sentences consecutively or one after the other.
Yes.
Do you understand the court decides to order or impose a sentence other than what the negotiated plea is? You have the right to withdraw that sentence, that plea.
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony which may carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 24 SC 005576, criminal damage to property in the second degree and possession of a firearm by a convicted felon?
Guilty under Alfred.
Has anyone forced you, threatened you, or promised you anything to get you to enter this plea?
No.
Is it your decision to waive these rights and enter this plea because you're in fact guilty pursuant to Alfred?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state will believe the evidence would show at trial that on October 8th, 2024 at 1278 Central Avenue in East Point, Georgia, that officers in Fulton County, the officers responded to Payless Automotive in regards to a shots fired call. And there they spoke with the victim who indicated that a blue Chevrolet Impala was shot. It had damage to the right side and rear passenger window. The victim was outside and was able to observe the defendant, Mr. Nolan, who was riding in a pink Honda CRV, which he obtained from the victim, Mr. Riley. He was dissatisfied with the vehicle and complained about a catalytic converter that was missing. And they observed him shoot up, I guess, the vehicle. And when Mr. Nolan was arrested later on, officers did kind of see or capture on video that there was a weapon that was recovered from Mr. Nolan's person that was consistent with Mr. Nolan having a weapon. Mr. Nolan is a convicted felon and is prohibited from owning or having firearms.
And did you say the Honda CRV he was driving was pink?
Correct. And that's how the victim was able to know that was Mr. Nolan, because he had just sold him a pink CRV that was experiencing some issues, but nonetheless.
And he was mad about the catalytic converter, not the color.
And then shot up the Impala.
Okay, got it. Thank you. Ms. Jackson, last case of the day.
Yes, sir. There are 18 cycles. The last arrest was October the 17th, 2024 in East Point, Georgia for reckless conduct. There was no disposition for that arrest. He does appear to be on first offender probation in DeKalb County for aggravated stalking. That disposition date was August the 24th, 2018, and the term is for 9 years. He has a misdemeanor sentence and a conviction. He received a nolo contendere sentence in 2023 out of Cobb County for obstruction of an officer. And there was a conviction in 2022 out of Cobb County for obstruction of an officer.
They closed it about
Nothing in addition.
2022.
All right, thank you so much. We'll see you soon.
Thank you. Have a great one.
You too.
Oh, okay.
Yeah, they resentenced
It
me.
took away the person.
Judge, I believe I neglected to state what the state's recommendation was.
I was going to come back to you on that. What do you have?
We are recommending 5 years to serve 6 months, balance on probation, anger management, 40 hours community service. He already has his diploma, so he does not need to obtain a GED, to have no contact with the victim and to stay away from the incident location. He's also needs to forfeit any guns in his possession.
Okay.
And I believe Mr. Nolan has spent some time in custody, and Ms. Rios will speak to that.
He has. All right. Ms. Rios.
Yes, Your Honor. Mr. Nolan is 31 years old. He was working at AutoZone in Waffle House in Big Game, and my understanding is that he can for sure go back to Waffle House and Big Game and possibly AutoZone based on what his family has told him. He has a newborn child, and he has a 5-month-old and a 9-year-old child. So he wants to be out to be able to provide for all his children and get back to work. He was also going to the Atlanta Institute of Music. He was getting his bachelor's in sound production. He wants to be a producer and do the contracts and beats and all that goes along with producing music. So I'm asking that you accept the plea as negotiated. I believe he did 6 months in custody already. And also, he just wanted me to let you know that he's not on probation anymore in DeKalb. That case has been closed.
Okay. That was the first offender, ag stalking?
Yes, sir.
Okay. The third place of work you said was Big Game?
Yes.
What is that?
It's a restaurant.
A restaurant?
Yes.
What did you do at Big Game?
Prep cook.
What kind of restaurant?
It's like, you know, wings and stuff like that. Like they do like Super Bowl parties.
It's more of a sports bar kind of place?
Yeah.
Okay. All right. Thank you. Ms. Simpson, what does your system show about whether Mr. Nolan is still on probation? Meaning he lost the first offender? Okay, and when he was adjudicated guilty, was there more probation or they basically closed that out?
It states that he was resentenced to 5 years to serve 2, with the balance on probation, with credit for time served since August of 2018.
Okay.
So that was it about expired.
Okay, got it. Mr. Nolan, anything you want to add to what we've heard so far?
Not really.
No? Okay. Did you purchase a pink Honda CRV?
Yeah, it was red.
It was red. You're going to defend that, not pink? Okay. Felt like you were a Mary Kay or something.
Right.
All right. And Mr. Riley is the guy you got it from?
Yes.
And does he run, I think it was called like Payless Auto? Is he like the guy who, or this was just a?
No, this was just a lot that he was just on.
Okay. And were all the cars, that was his lot? Like he was a used car dealer or he just happened to have a reddish, pinkish?
Yeah, he happened to have a red car that I bought from.
Okay. Got it. And he also had an Impala?
Yeah, he had an Impala.
Okay.
All
right.
Yeah, if I can add. Yeah, he had cut off the catalytic converters to all 3 of my cars.
Really? Yeah. So he could sell the catalytic converters. When you say all 3 of your cars, like he snuck onto your property and did that, or you bought 3 cars from him and none of them had a catalytic?
I bought 2 cars from him. It was a Saturn, and I bought a
Saturn.
Yeah, I bought a Saturn. I forgot what it was, but it was a Saturn, and I bought a Honda from him.
Yeah.
Then, you know, I already had my Dodge Charger. He cut all the catalytic converters off my car.
When they were on his lot, or he came to where you were?
Came to where I stayed at.
And why do you think Mr. Riley did it as opposed to someone else?
They had him on camera.
Oh, who's they?
East Point.
Okay.
East Point Police. They had him on camera. I mean, not East Point Police, but Motel 6. They had him on camera.
You were staying at a Motel 6, and all 3 of your cars were in the parking lot.
Mm-hmm.
And he came and collected the catalytic converters. Got it. And that made you upset.
I wouldn't say I did it though.
I'm not saying you did it. I'm just asking. Okay.
Yeah.
How did you know he did it? Did you see what was on camera, or?
Yeah, they let me get the hotel footage. They let me get the footage from the
police did?
Nah, the hotel. I know somebody that worked up there.
Okay. Yeah. All right. And all that happened before this Impala mysteriously got shot up.
Yeah.
Okay.
Yeah.
All right. Anything else you want to add?
That's it.
And as I understand it, you have 3 kids, one who's brand new, one who's only 5 months, and then an older one.
Yeah,
How many moms across the three? It's got to be at least two.
3.
Three moms. Okay. Any of the kid, when you get out, where are you going?
Right now I'm supposed to be getting an apartment, so I'm going to a hotel. I'm probably gonna be back in East Point, or most likely College Park.
Okay.
Yeah, I might be in College Park on Old National.
Any reason you need to be in East Point? Because I'm trying to figure out a way to keep you away from Mr. Riley.
My mail, I'm receiving mail out there, and I do have like clients I do work on cars for out there, but I'm never like where his shop is and everything is like nowhere near me.
Okay.
Yeah.
All right. Got it. All right. Well, Mr. Nolan, I find there's a factual basis for your plea. I understand it's an offered plea, but if the evidence played out the way the state says it would play out, a jury could find you guilty. Who knows? It's sort of a mystery. You'd have your defense and a good defense attorney. But I do find there's a factual basis and that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Voluntary, you know what the word means, but no one's forcing you to enter this plea. Do you agree with that?
Yes.
All right. I'm sentencing you pursuant to the Probation Options Management Act. I didn't hear you say anything, Ms. Davis, about restitution. Are we in a space right now where there's not a number you can link to all of the gunshot damage to that poor Impala?
That is correct. And we did attempt to make contact with the victim and weren't able to really get them on the phone to discuss.
Okay. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Davis?
Yes, Your Honor.
And Mr. Nolan, can we electronically sign the indictment on your behalf?
Yes.
We will do just that. And I'll take this as an offered plea. I will sentence you on count 1 to 5 years to serve 6 months with the balance probated. And count 2 will be the same, 5 years to serve 6 months. Those counts will run concurrently with each other, meaning at the same time. Special condition number 1, complete an anger management course. Number 2, 40 hours of community service. And number 3, no contact with Mr. Riley. And finally, number 4, stay away from his place of business. And do we have that? I guess that's the incident location,
Yes, it is.
which was what, Central Avenue? You gave me some
I'm
numbers.
sorry, 1278 Central Avenue in East Point, Georgia.
Got it. 1278 Central Avenue. And if you are going to be rattling around in East Point, it sounds like it's nowhere near Central Avenue.
No.
Okay, that's a good plan. Ms. Rios, anything else on behalf of Mr. Nolan?
No, Your Honor.
Ms. Davis, on behalf of the state?
No, Your Honor.
Probation. When he gets out, when you need to report within 48 hours of your release. You'll want to report to the Fulton County Probation Office. Do you know where that is?
Isn't it by Garnett Station, right?
Yes, it's about 2 blocks from here on Memorial Drive.
Okay.
You can see it if you're up on the Garnett Station. There's a big sign on it that says, I saw it for the first time. I took Marta to the airport recently and it's, yeah, well done. It's sort of inviting. I almost want to show up there. So, okay, that's it. All right, I'll be back out in a few minutes. We just need one person for that. But we have our trial calendar discussion. Thanks, Ms. Rivers.
Okay, Judge, have a good evening.
You too. Well, thank you, Ms. Davis and Ms. Rios. That was lots of pleas. It tastes good with tuna. You'll enjoy it. All right, I will be back.
Did you? That's why there's only yellow left. Somebody's taking all the good colors.
I put like word thing, and like, he's like, no, take more. Oh, that was great, okay.
I like, right?
Oh, what about only one in here?
Sorry.
All right, I'm gonna step out and call Miss Rockwell. So please drag me back in here. She's not gonna let me off the phone.
Oh, she got something to tell you?
She has something on the trial calendar. So.
Hmm?
The trial calendar. Yeah, we survived. That was a very intense Sunday. Okay. Actually, I'll just step back here. Who did she have on that calendar? I would say, let's see, the club. Anthony Eugene Philip, like throw it up and fire off. He probably is in. Who's going?
She always had the one kind of issues.
Like, right.
Y'all tell me.
Good girl.
Y'all still going strong?
You missed all. You always come in at the end, so you, I think you're good at emergency.
Oh, yeah, I let y'all do all the work and I just come in and.
I'm just so you the same, all right. Everything was good, I know.
Yeah. So just that?
Pretty much, yeah, just one more. Oh, I said, you missed all.
Hey, where Gordon?
Big Gordon, so in the back. He might want to go take the guy down.
Okay. All right.
Oh man, I'm glad there's no court tomorrow. I will be working from home. So I'm glad. Thursday's gonna be long too. Then we have fun on Friday, but then it starts at 1. I'm gonna start at 1.
Yeah.
That lemon candy was really good.
See, now you see how I know.
Mm-hmm. That was great. I'm gonna put that back on your table for pizza.
No, keep it. I've eaten like 5 of those. Keep it in there. I'm sure the calories. Yeah. I ate way too many. I was just like munching on them.
Oh, you gonna stay around and hear what we gonna do?
I might as well help me out.
You guys did a number on them, still back there working.
Oh yeah, today was a day.
I'm going like this.
Right. I'm not gonna catch all that other time.
All good though.
Yeah.
So you're making that September calendar look more manageable.
Yeah.
It was out of control.
Oh wow.
So you're a lot better. You'll probably still say, there's a lot of cases, but it was really over my limit of what, it's a certain amount I had to put. It was reaching 40, that's too many.
40.
How
did it get like that? We can start putting them in January.
You know, when they say, we're not ready, just go to the next calendar, just go to the next calendar. And it's like, okay.
Have you thought about maybe when we have final plea, and then not having it the next month, but like 2 months out, that way the people for final plea to get resolved don't go on the next calendar? Why just look at me like that? It was a good solution.
I leave them on the calendar so that we don't put anything else on there.
Because you know what happens.
Oh, okay.
Yeah,
Okay.
you'll be spinning.
That in your mind, not just you, that I might work with that.
Oh, yeah. Yeah.
If it stays under your nose, then you're like, okay, I'll get it.
Mm-hmm.
Or then you're like, I know nothing about this case. Who is this person? Because it's been so long since you've seen them.
True.
Believe me, you used to do status calendars, we did final plea, then final plea trial calendar. I mean, you mix them all together, which is.
It's too much. This is the way it works the best. Okay.
Yeah, because it kind of forces everybody to stay on task.
That's true.
You know, he doesn't allow a lot of continuances, which helps.
Mm-hmm.
And they can continue, it just, you know, what you guys do really well, so it works. So I don't have that night join do a Zoom on Thursday.
John will show me. Okay. Only thing with him, I just need to go over his plea rights, but can I just do a breakout room quickly to do that? Okay.
And we'll have enough going on, but
I don't have a lot going on Thursday. I don't think they have a lot of, yeah, I don't have any pleas. But because there's already been.
Still has
No,
one
most of it
case
was
that's
resolved.
being indicted.
Yeah, there's only like two, I only have two cases, well, three, but one, yeah, I have one plea, I have one misdemeanor. Christine. That's it.
where's Miss Wood? I want to hear what she has to say.
She'll be on.
This
All right, well, we can have that conversation. What's that? That's nothing. Why is that not clearing up? Oh.
I didn't
Missed it.
call it.
What
time you only get one you have to.
Oh, I think we're good. This won't, I missed a request from Ms. Rivers for a break.
The same question, I'm like, where is this happening? You don't have anything said.
All right, whose stuff is that?
Mr. Buddy.
Oh, he's around. Excellent. Thought he was busting out right there. Nope. Deputy Gordon. All right, trial calendar discussion. We have a 2-week calendar that starts next Monday. And I was really hoping we'd try one of my oldest murders, been in for 3 years, but I don't know that we're gonna have a defense attorney. I think her current bond is that she's not allowed to practice law, and I haven't heard that she's gotten that amended. So I don't know if she'll show up on Thursday or not. We'll see, but let me start making my list. Hey there.
Hey, Joe.
How are you?
How are you?
All right. We're just getting started. You're ready to go on to it if we have a defense attorney.
Yes.
All right. Do you have a preference as to week?
2.
Okay, always later. All right. Week 2. Melvin Sampson. I don't recognize the defense attorney. Is it Ms. It's not a PD case?
That's Miss Ruff. I emailed her an offer.
No, I will look at it. Hold on one second. Oh. Thank you.